Have you done a markup before?
I have, but they marked it, but it never turned. It didn't go off. It was a regular length of markup. Even though they thought of it.
Yeah. Well, you know, it's kind of hard to say. They these things can move along, but they don't always. I think the fact that they close
You might change it again.
Left-handed. Committee will come to order. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. I now recognize the gentleman from Wisconsin, Mr. Fitzgerald, to lead us in the Pledge of Allegiance. To the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Our first order of business is ratifying an updated subcommittee roster. Would the clerk please distribute the updated roster? This roster appoints Mr. Roy as chairman of the Subcommittee on the Constitution and Limited Government. I ask unanimous consent that the committee approve the appointment and assignments as shown on the roster. Without objection, the subcommittee roster is approved. Pursuant to notice, I call up H.R. 5736, the Federal Accountability in Interviews Reform Act, for the purpose of markup, and move that the committee report favorably to the House. The clerk will report the bill.
H.R. 5736 to require interviews.
Without objection, the bill will be considered as read and open for amendment at any point in time. The chair now recognizes himself for an opening statement. First, I would like to say thanks to Mr. Tiffany for introducing this bill and take a moment to thank my colleagues across the aisle for working with us on this important piece of legislation. The FAIR Act would require FBI, ATF, DEA, and Marshal Services officers and employees to record both custodial and non-custodial interviews of individuals suspected of having committed a federal offense. In 2006, the FBI issued a report in favor of recording interviews with benefits including reduced court time for officers to appear at suppression hearings, improved court efficiency with fewer pretrial motions to suppress statements and confessions, officer efficiency due to no longer needing to review and piece together notes from interviews, reduction in lawsuits stemming from frivolous claims of misconduct during custodial interviews, protecting taxpayers from civil settlements stemming from wrongful convictions, and the ability to use recordings for training. In 2014, the DOJ under President Obama created a presumption that interviews of federally detained persons be electronically recorded. The problem is in their guidance, the DOJ defined custodial interviews as anything after indictment before trial in a federal building. This quite simply this report was a loophole that you could drive a semi-truck through. And we know this from cases of Paul Manafort and Michael Flynn, that this guidance can be used to actually avoid recording interviews of witnesses and suspects. Any reasonable person would have considered these interviews investigative and potentially custodial. And if it is happening in these high-profile cases, we know that it is happening in investigations of ordinary citizens. The recording requirement for an interrogation should exist where the subject is entitled to invoke some of their most seminal constitutional rights. There is no reason why the premier law enforcement agency in the world cannot get into the 21st century. All of the arguments in the past that have been used for not recording interviews simply don't exist today. It was too expensive. It was too cumbersome. It doesn't allow for the free flow of conversation. The DOJ and the FBI reports refute all of these arguments, just like the real-world experience of 25 states that require the recording of interviews. Interrogations can often last for hours, and notes cannot account for everything. And trials often happen years after those interviews, making it ridiculous to believe that agents or subjects can cognitively recall specific details if they are not recorded. Can any of us recall a detail of every conversation we had 3.5 weeks earlier, regardless of what you were doing? And agents are allowed to lie to their suspects. But when those same witnesses or subjects lie to law enforcement, they are often charged with a crime or their plea deals are revoked. Recorded interviews protect law enforcement, they protect criminal defendants, they reduce the burdens on court systems as they reduce jury trials, and probably most important today, they increase public trust in law enforcement and the criminal justice system. Recorded interviews protect all these things because it's an irrefutable transcript of what actually happened. That's something we drastically need at this point in time. Again, I cannot see why the most premier law enforcement agencies in the world can't pull their iPhone out and record an interview. And I should say I've dealt with this at the state and local level, with departments that have budgets which are minuscule in compared to federal law enforcement. And they all were hesitant at first. But after they implemented the policy and have been recording interviews for a period of time, they all say the same thing. It benefits their department. It helps train new officers. It protects those individual officers. It increases transparency, and it reduces the likelihood of trial. I was a pretty good lawyer, but I was never good enough to overcome a recorded confession. I urge my colleagues to support this bill, and I yield the balance, and I yield back. Chair would now recognize the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 5736, the Federal Accountability and Interviews Reform Act, would require the FBI, ATF, DEA, and the U.S. Marshals to record their interviews of suspects in most circumstances. When Representative Armstrong, proposed similar language as an amendment to the George Floyd Justice and Policing Act during our markup of that bill in 2020, multiple Democratic members expressed support for the general principle behind Mr. Armstrong's amendment, which is that recording interviews promotes justice, accountability, and efficiency in our criminal justice system. I said at the time that if he withdrew his amendment, we would be willing to work with the Republicans, examine it further, and see if we could come to an agreement. I'm pleased that today, with an amendment that will be offered shortly, we have finally reached the bipartisan agreement we all hoped to achieve. Interview recording has become a best practice among law enforcement agencies. At least 27 states require recording of interviews in at least some circumstances, and many additional jurisdictions voluntarily record interviews. This is not surprising when you consider the many advantages of having a full audio or video recording of an interview. A recording creates an objective record that captures far more detail than any officer would ever be able to write down in notes or in an after-the-fact report. The availability of recorded interviews with suspects permits judges to review confessions and the events leading up to a confession, reducing wrongful convictions and deterring improper interrogation tactics. Recordings also reduce the need for pretrial litigation over the admissibility of a statement and other evidentiary disputes. That is why the Department of Justice has a policy, albeit a discretionary policy, that presumes that interviews will be recorded, with video recordings strongly encouraged. Video recordings allow us to see all the nonverbal cues that provide the full context for a suspect's statement. DOJ recognizes that a picture is indeed worth 1,000 words. Unfortunately, this legislation as introduced does not extend the bill's protections to non-U.S. citizens. The Equal Protection Clause demands that citizens and non-citizens be treated equally by our criminal justice system, and indeed there is no other provision of criminal procedure, no rule or regulation designed to safeguard the rights of criminal defendants that applies only to citizens, meaning that this portion of the bill is unlikely to survive judicial scrutiny. It would also be terribly difficult to enforce in practice, placing an undue burden on law enforcement to attempt to accurately determine a suspect's citizenship before questioning them. I'm therefore pleased that an amendment will be offered shortly to apply the bill's protections to all individuals suspected of a crime and to encourage video recording. With those changes, I will be proud to support this bill. After many years of hard work, I am proud that we could come together and reach bipartisan agreement on this important issue, and I hope that we might find common ground on other issues to prevent wrongful convictions and promote justice. I thank my colleagues across the aisle for working with us in a bipartisan fashion to ensure that we have the strongest possible version of this legislation. Thank you, and I yield back.
Without objection, all other opening statements will be included in the record. The chair now recognizes himself for the purpose of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 5.
Without objection, the amendment in the nature of the substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes himself to explain the amendment. This amendment, in the nature of a substitute, identifies federal law enforcement agencies within the Department of Justice that will be subject to the recording requirement. It also includes a number of common sense exceptions and other improvements of the bill. I urge my colleagues to support, and I yield back. The chair now recognizes the gentleman from Wisconsin, Mr. Tiffany.
Mr. Chairman, I'd like to move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. I want to take a moment to thank my colleagues across the aisle for working with us on this important piece of legislation. I understand that there will be an amendment to the amendment in the nature of the substitute that will ensure that these federal law enforcement agencies record interviews with all persons suspected of having committed a crime, not just U.S. citizens. This legislation requires FBI, ATF, DEA, and Marshal Service officers and employees to record both custodial and non-custodial interviews of individuals suspected of having committed a criminal offense. Since 2014, the DOJ has had a policy in place that creates a presumption that custodial interviews are electronically recorded. It also encourages non-custodial interviews to be recorded. But the policy provides no penalties or consequences for not recording interviews. Without a law in place that requires interviews to be recorded, FBI agents and officers are free to ignore the policy without any consequences. In lieu of a policy requiring interviews to be recorded, the FBI's standard practice is for agents to take notes during an interview and summarize those notes in Form 302. However, without a verbatim record of what was said during an interview, prosecutors, defendants, and judges are often left with a Form 302 of the interview that merely summarizes the FBI agent's characterizations and memories of what was said during the interview, or worse, the Form 302 mischaracterizes what was said. We've seen the FBI weaponize these 302s against Republicans. In 2016, the FBI began a counterintelligence investigation into Lieutenant General Michael Flynn for potential violations of the Foreign Agents Registration Act. On January 24, 2017, FBI agents Strzok and Pientka interviewed Flynn, who was serving as President Trump's national security advisor at the time. Then FBI Director Comey later stated that under a more organized administration, he probably wouldn't have gotten away with it. FBI handwritten interview notes from then FBI agent Bill Priestap state that one of the goals in the January 24, 2017 Flynn interview was to, quote, get him to lie so we can prosecute him or get him fired, end quote. The interview was an obvious pretense to charge Flynn with an 18 U.S.C. 1001 violation, which Special Counsel Miller's office did. This bill contains exceptions to the recording requirement to ensure that the FBI isn't required to record interviews involving confidential informants, undercover officers, and in other circumstances where there is an immediate threat to public safety. This bill will also ensure fairness for criminal defendants and promote accountability for bad actors in the FBI. If the FBI can do this to a 3-star general who served this country for over 30 years, you better believe they can do it to you. The need for this legislation is urgent. I urge my colleagues to support the legislation, and Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Nadler from New York.
Mr. Chairman, I rise in support of this amendment. This amendment would correct a typographical error in the ANS, and it would make 2 substantive changes. It would encourage video recording, and it would extend the bill's protections to interviews of all individuals, not just United States citizens. These changes are essential to my support of H.R. 5736. As I explained earlier, video recordings are superior to audio recordings. They provide a more complete record of a suspect's interview that allows the reviewer to assess all the circumstances of an interrogation, not just the suspect's words. While they're not always practicable, video recording should be encouraged where possible. The amendment also applies the requirement of an electronic recording of a suspect's interview to any individual suspected of a crime, not just United States citizens. I appreciate our colleagues' willingness to work with us on the constitutional questions and practical problems that would result from drawing a distinction between citizens and non-citizens in this context, and I'm glad we could reach a bipartisan agreement. I urge my colleagues to vote yes on this amendment, and with the amendment's passage, I would urge them to vote yes on the bill. Thank you. I yield back.
Gentleman yields back. Does anybody else seek recognition? Ms. Dean from Pennsylvania.
I move to strike the last word, Mr. Chairman.
Gentlewoman is recognized.
Thank you very much. I rise in support of the amendment to H.R. 5736, the Federal Accountability in Interviews Reform Act. I agree with my colleagues on both sides of this hearing room that recording interviews will generally benefit both law enforcement and criminal suspects. In particular, we must eliminate the risk of false confessions prompted by improper interrogation techniques. Nevertheless, I want to be on the record to say that I have concerns that the bill does not require officers to tell interviewees that they are being recorded. Simple disclosure would allow all interviewees to make a fully informed decision about how to exercise their constitutional rights. And telling suspects that they are being recorded is also in keeping with the spirit of the bill, which is appropriately titled the FAIR Act. Again, I believe more could be done to improve transparency. Nevertheless, I agree that this bill is a step in the right direction, and I will offer my support. I yield back.
Gentlelady yields back. The chair has an amendment at the desk. Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 57.
Without objection, the amendment is deemed as read. Chair now recognizes himself to explain the amendment. This amendment ensures that federal law enforcement agencies record interviews with all persons suspected of having committed a crime, not just U.S. citizens. Additionally, the amendment notes that the interview may be recorded with electronic video technology and that video recording is preferred. I urge my colleagues to support this amendment, and I yield back. Who seeks recognition?
Mr. Chairman.
Chair recognizes Ranking Member Nadler from New York.
Mr. Chairman, I got the cart before the horse. I already explained my reasons for supporting this amendment. I commend the chairman for the amendment, and I urge everybody to support it, and with it, to support the bill. I yield back.
Gentleman yields back. Who seeks recognition? Seeing none, the question occurs on the amendment. Those in favor say aye.
Aye.
Those opposed? In the opinion of the chairs, the ayes have it. The amendment is adopted. Is there any further discussion on the bill?
Mr. Chair.
Gentleman from Texas is recognized. Mr. Moran.
Mr. Chairman, I see move to strike the last word. Mr. Chairman, although I support the concept of this bill and certainly the spirit of it, the details are something I can't support at this point. A couple of things I want to point out. First, the chair noted in his opening comments that upwards of 25 states require interviews currently, but I'll note that I couldn't find any that require interviews of both custodial and non-custodial interviews. I think that distinction is very important, and I certainly recognize that there have been problems with the Department of Justice in the way that this has been applied, and I want to correct those problems. And I think that if we take a bigger look at this issue, we could do things like redefine how they're defining custodial. If that's the issue, we certainly can define that by statute and make sure that we record custodial interviews. But to require both custodial and non-custodial interviews, I think prevents our law enforcement agencies to do the job that they need to do in the manner that they need to do it. Also, I'd note that when you look at the Uniform Electronic Recordation of Custodial Interrogations Act, which is really the uniform act that most states looked at to enact their state statutes, it does not require an automatic inadmissibility as a default or as the only remedy for failing to interview or to failing to record. In fact, most statutes allow this to be just considered as a factor of inadmissibility and reliability and can be cured with a strong instruction by the court. As an alternative, we could consider things like a presumption of inadmissibility that's rebuttable with corroborating evidence. There's ways to get around it so that we don't just say, well, look, in any instance, if you don't record this, then it's out and it can't be admissible under any circumstances. I think we need to allow courts to have the discretion to say, hey, there's a situation here that we need to allow for this, or give the jury an instruction in this particular instance. There's not some safe harbor provisions and exceptions that I would expect to see. Things like what happens if there's equipment malfunction. or what happens if there's a good faith belief that the recording is not required, but all of a sudden then it is argued that it is required. Now we're providing defense attorneys the ability to get folks out of cases that shouldn't get out of these criminal charges. What happens if the safety of the individual or the protection of the identity? I know we've identified specifically the exception for confidential informants, but what about recruiting confidential informants? It doesn't talk about prospective confidential informants. So now we're in a situation where what if we have a confidential informant or a witness under this statute, anybody that is suspected of having committed a criminal offense must have their interview recorded. Well, what if it's not the criminal offense being investigated? What if it's another criminal offense? Now we've got to record witness A to crime B because he's suspected of a criminal offense in a different venue. So that I think creates some issues as well. You talk also about the ability for this to come out in rules. We're giving the Attorney General, Merrick Garland, the ability to write his own rules to carry this out, and that concerns me. I think we need to have more details, not be so overly broad in our attack of this issue. Again, I recognize the Department of Justice has misused this, and we need to create and craft some legislation to fix this, but I think this is a little bit overly broad. I want to also point out that under this statute, there's no division between any crime. So it's for all crimes. When you look at most states that have adopted statutes like this, they reserve it for the worst crimes, for murder, for rape, for felonies at least. Here we're saying for any crime that is being investigated. Now we're going beyond just what I think the states have found to be the better exercise, and that is in those instances when we have those instances where we have custodial interrogation of high-level crimes, felonies, you can define the crimes however we want to in this body, in this statute. But when we just say any custodial or non-custodial interview, and it's for any crime, and there's no exceptions, and there's no way for there to be any remedy other than inadmissibility in court, all of those issues give me pause to support, and without revisions to address those concerns, I cannot support this bill. I yield back.
The gentleman yields back. Who seeks recognition? I ask unanimous consent that a letter from the Federal Bureau of Investigation Agents Association be included in the record. Without objection, so ordered. The question is on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye.
Aye.
All those opposed say no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on the favorable reporting of the bill as amended. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it, and the bill is...
Could I request a recorded vote?
A roll call vote has been requested. The clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Issa votes aye. Mr. Buck. Mr. Gates. Mr. Gates votes aye. Mr. Biggs. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Roy. Mr. Bishop. Ms. Sparts. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Bentz. Mr. Klein. Mr. Klein votes aye. Mr. Armstrong. Yes. Mr. Armstrong votes yes. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes yes. Mr. Kiley. Mr. Kiley votes aye. Ms. Hageman. Ms. Hageman votes aye. Mr. Moran. Mr. Moran votes no. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Ms. Ballant?
How is Ms. Escobar recorded?
Ms. Escobar is not recorded. Ms. Escobar votes yes.
How is the gentlelady from Washington recorded?
Ms. Jayapal is recorded as aye.
How is Mr. Correa from California?
Mr. Correa votes aye.
How is the gentleman from North Carolina, Mr. Bishop, recorded?
Mr. Bishop is not recorded. Mr. Bishop votes aye. 22-21.
The clerk will report the roll.
Mr. Chairman, there are 22 ayes and 1 no.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit bills. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to Notice 1, I call up H.R. 1709, the Tribal Firearms Access Act, for the purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1709, to allow members
Without objection, the bill will be considered as read and open for amendment at any time. The chair now recognizes the gentlelady from Wyoming, Ms. Hageman, for an opening statement.
Thank you, Mr. Chairman. H.R. 1709, the Tribal Firearms Access Act, is a simple and straightforward bill that allows members of federally recognized Indian tribes to use their valid identification documents issued by tribal governments to obtain a firearm from a federally licensed dealer. This bipartisan bill was introduced by our friend from South Dakota, Representative Dusty Johnson, and is co-sponsored by a number of members with tribes and reservations in their districts. The right to keep and bear arms secured by the Second Amendment is important to the day-to-day lives of many Native Americans, particularly those who reside in rural areas. However, under current law, federal firearms licensees, or FFLs, are required to verify the identity of firearms purchases through examination of a valid identification document, which is defined in another section of the code. That definition does not include identification documents issued by federally recognized tribes, although tribal identification documents can be used for many other purposes. For instance, tribal identification documents are accepted by the Transportation Security Administration, or TSA, to pass through TSA checkpoints. In Washington state, they can be used to verify the age of a person purchasing alcohol or cannabis. And in Wisconsin, they can be used for the purpose of purchasing alcohol and tobacco, selling or recycling non-ferrous scrap metal, transactions with pawnbrokers and jewelers, obtaining prescription medicines, and even voting. Tribal IDs may be the only forms of identification many Americans possess. Nearly 1 in 5 Native Americans have little to no internet access to get another form of ID online. Moreover, the nearest Division of Motor Vehicles office may be hundreds of miles away. These Americans should not be denied their Second Amendment rights because of lack of access to another form of identification. This bipartisan bill ensures that law-abiding Native Americans may exercise their Second Amendment rights. I urge my colleagues to support this bill, and I yield back.
The gentlelady yields back, and I now recognize the ranking member, Mr. Nadler from New York, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the goal of this legislation is a reasonable one: to ensure that identification documents issued by tribal governments are accepted as a valid form of identification when purchasing a firearm. But there is more than one way to achieve this goal through legislation. Indeed, the bill's sponsor, Representative Dusty Johnson, introduced this bill last Congress with text that added tribal governments in one part of the law. This Congress, he introduced the bill with the same title and the same purpose, but added tribal governments in a different part of the law. Both versions would allow someone to use a tribal ID to buy a firearm, but only the earlier version would extend the inclusion of tribal IDs and tribal governments to other areas of the law, such as making sure tribal documents are included in the federal definitions of identity theft and fraud involving IDs. I was pleased that our colleagues were open to further discussion on this important matter when we raised this issue with them. I understand that our Republican colleagues will be working with us to amend the bill as it proceeds to the floor so that we can achieve a bipartisan outcome. With this understanding, we will examine the full implications of this important drafting distinction and solicit input from tribal governments and the people they represent. It is our hope that we can reach an agreement that includes tribal IDs, tribal governments, and Native Americans in a more expansive way than just allowing tribal IDs for gun purchases. Such an agreement would serve to correct the broader injustice of failing to include tribal governments in more provisions of the law, and would prevent tribes from having to seek recognition of one law or one right at a time. I thank Chairman Jordan and his staff for their responsiveness and willingness to collaborate on this bill. With the understanding that there will be continued efforts to improve the bill, I will vote to advance this legislation today, and I urge my colleagues to do the same. Thank you, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. And briefly, I would just note that the majority and minority staff have been discussing this bill. I understand that there is bipartisan interest in this bill and making sure that everyone is comfortable with the substance. After the bill is favorably reported today, we commit to working with the minority as it goes to the floor to accomplish that. The chair now recognizes the gentlelady from Wyoming for the purpose of offering an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1709.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentlelady from Wyoming to explain the amendment.
Thank you, Mr. Chairman. This amendment in the nature of a substitute makes a small but important change. It makes it clear that the tribal identification must have a photograph of the individual. I urge my colleagues to support it, and I yield back.
The gentlelady yields back. Who seeks recognition? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye.
Aye.
All those opposed? In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is unfavorably reporting the bill as amended. All those in favor say aye.
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 All those opposed say no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to Notice 1, I call up H.R. 1508, the Travelers Gun Rights Act, for the purpose of markup, and move that the committee report it favorably to the House. The clerk will report the resolution.
H.R. 1508 to amend Chapter 44.
Without objection, the bill will be considered as read and open for an amendment at any point. The chair recognizes the gentlelady from Wyoming, Ms. Hageman, for an opening statement.
Thank you, Mr. Chairman. H.R. 1508, the Travelers Gun Rights Act of 2024, is a simple and straightforward bill that allows active duty service members, their spouses, full-time RV travelers, and those without a permanent residence to legally purchase firearms with either a private mailbox or a post office box number. This bill is sponsored again by my friend from South Dakota, Representative Dusty Johnson, and is co-sponsored by several members with military members and full-time RV travelers in their districts. Spouses of American servicemen and women, particularly those with permanent residences other than where they are currently stationed, should have the ability to exercise their Second Amendment rights. However, under current law, the ATF mandates firearms buyers to list their legal physical residential address when purchasing a firearm, prohibiting the use of P.O. boxes and private mailboxes. This legislation will allow thousands of Americans in diverse living situations, including the spouses of active duty military personnel and RV residents, to exercise their constitutional rights to purchase and possess a firearm. For instance, the spouse of an active duty military member with a permanent address in their home state but stationed elsewhere would be lawfully eligible to purchase a firearm. Since 2020, around 1 million Americans have shifted to full-time RV living, a change that currently hinders their ability to purchase firearms due to their non-traditional residences. Supporters, including the National Shooting Sports Foundation, stress that using a P.O. box for mail, as thousands of Americans do, should not obstruct an individual's constitutional right to own a firearm. These Americans should not be denied their Second Amendment rights because they lack a permanent residence and have non-traditional living arrangements. I urge my colleagues to support this bill, and I yield back.
Yields back, and the chair now recognizes the gentleman from New York, Ranking Member Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 1508, the Travelers Gun Rights Act, would allow the use of a P.O. box rather than a physical address to prove state residency when purchasing a firearm from a federally licensed firearm dealer. While perhaps well-intentioned, it opens a gaping loophole that would seriously undermine law enforcement's ability to connect a gun at a crime scene to a person at a physical address. Federal law regarding the transfer of firearms turns on the state of residency of the buyer and the seller. While there are many exceptions and caveats, generally a person can buy a firearm only from a seller within the state in which he or she resides. This is true whether the seller is a federal firearms licensee, an authorized gun dealer, or a non-licensed private seller. When a person buys a firearm from a dealer, there are additional rules and procedures related to residency. For example, the dealer has an obligation to ensure the sale does not violate the law. To do that, the dealer must know the buyer's state of residence. Further, dealers must keep sale records so that when a gun is used in a crime, law enforcement can trace where that gun came from. To achieve these goals, the law requires a buyer to fill out a form which requires the buyer to provide a, quote, current state of residence and address, unquote, and prohibits providing only a post office box. The Gun Control Act does not define state of residence except for members of the armed forces on active duty, who are residents of the state in which their permanent duty station is located. For decades, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or ATF, has filled in the gaps of this law through reasonable regulations and guidance. For example, ATF regulations provide that a person is a resident of the state in which he or she is present with the intention of making a home in that state. A 2001 ATF ruling clarified that military personnel who have a permanent duty station in one state but have a home in a neighboring state have two states of residence under the law. ATF has also clarified that, quote, a U.S. citizen with homes in two states may, during the period of time the person actually resides in a particular state, purchase a firearm in that state, close quote. A portion of this bill codifies these residency regulations. One provision of the bill also extends the dual state residency afforded to active duty military members to their spouses. If that was all that this bill did, I would support it. Unfortunately, this legislation does much more than that. The bill provides that a person who does not have a physical residence in any state can establish residency in a state merely by maintaining a private mailbox or post office box in that state. This would mean that in filling out the required form to purchase a gun from a dealer, a buyer could provide only a P.O. box and no physical location. This is misguided and dangerous for several reasons. First, it is not clear that it is even possible for someone who is legally resident of the United States not to have a physical residence in any state. Everyone lives somewhere. The bill's sponsor said that this bill is intended to help, quote, full-time travelers who may rely on a P.O. box to receive mail. But even these full-time travelers reside somewhere and have a state of residence. Indeed, as he well knows, many of them reside in his home state of South Dakota, a state that has crafted laws for this population. South Dakota is one of a handful of states that issues driver's license for residents with P.O. boxes and treats P.O. boxes as a legal address. But the bill's own text does not apply to these full-time travelers since they have a state of residence in South Dakota. This is true even if they return to the state only occasionally, and even if their physical location changes frequently as they travel by RV, van, or boat. Moreover, no modification to the law is needed to ensure that those who rely on P.O. boxes as a legal address can buy firearms from a dealer. More than 16 years ago, ATF issued an open letter to all federal firearm licensees, acknowledging that some states issue driver's licenses with only a P.O. box, and that a P.O. box can be considered a legal address in some states. The letter reiterates the importance of verifying a purchaser's physical residence and sets out a, quote, variance process so that a purchaser can describe the actual physical location of his or her residence and provide identification listing only a P.O. box so that no person in this unique circumstance is prevented from exercising his lawful Second Amendment rights. Neither the form nor this ATF guidance requires a permanent address, so no one is prevented from traveling the country as a law-abiding gun owner. This variance process should be the end of the discussion with respect to the need for this bill. But even if this process, specifically tailored to this situation, did not exist, as it has for 16 years, there is a way to buy a firearm without providing any address or location at all. In many states, including South Dakota, a person can buy a firearm from a private seller, anyone other than a federally licensed dealer, without providing a physical address, without providing ID, and without answering a single question. This continues to be a major way in which criminals get guns, even when they are prohibited from having them under federal law. Rather than close this loophole, as House Democrats and a few Republicans sought to do last Congress, this bill's proponents ignore this fact so they can open yet another loophole that can be exploited by those looking to cause harm and not get caught. I understand that my colleague, Congresswoman McBath, will offer an amendment removing the P.O. Box provision and requiring a study of the effects it might have on law enforcement, national security, and gun trafficking. I will support this amendment and would be willing to support this legislation if the amendment is adopted by the committee. Without this amendment, however, I'm strongly opposed to this bill, and I will urge my colleagues to oppose it as well. Thank you, and I yield back.
The gentleman yields back, and the chair now recognizes the gentlelady from Wyoming to offer an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 150.
Without objection, the amendment will be considered as read. The chair now recognizes the and become base text for the purpose of the amendment. The chair now recognizes the gentlelady from Wyoming to explain the amendment.
Thank you, Mr. Chairman. This amendment in the nature of a substitute simply adds 2024 to the title of the bill. I urge my colleagues to support it, and I yield back.
The gentlelady yields back. Who seeks recognition? The gentlelady from Georgia, Ms. McBath.
Thank you, Mr. Chair. I have an amendment at the desk.
The clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 150.
Without objection, the amendment is reserved a point of order. Considered as read. Gentlelady is recognized to explain her amendment.
Thank you, Mr. Chairman. Before my colleagues undermine our law enforcement's ability to stop dangerous criminals, let's please do our due diligence. We absolutely must consider the unintended consequences this would bring and its effects on law enforcement.
Okay.
There is a reason physical residences are required for gun purchases, to allow our officers to track down weapons that are used unlawfully. The bill introduced by my colleague could mean more guns crossing our state borders, more jurisdictional issues, and more unresolved crime. Someone could go to a state in which they have no intention of establishing residence, establish a P.O. box, and begin purchasing guns. It's far too easy for this law to be exploited and abused by people with malicious intent. This bill would open interstate escape routes for murderers and violent crime without first finding out if these P.O. box changes would complicate an existing process for our already overburdened police force. Now, I'm sure there's another way to help the law-abiding individuals Mr. Johnson is looking to assist. But enacting this legislation without studying the drawbacks is absolutely not the way. This committee has had countless hearings on safety, yet here we are considering a bill that will complicate law enforcement's ability to trace and track firearms. We need to make sure this Congress fully understands the impacts that this bill will have on police efforts to get violent criminals and weapons of war off of our streets. This is an issue of national security, and as lawmakers, we should not cut off the ability of our officers to properly do their jobs and keep our communities safe, especially as this bill makes it easier for those planning to use the firearm in a criminal act to get away with murder. In fact, ATF 17 years ago sent a letter explaining why gun purchase forms needed a physical residence and provided guidance for those without a residential address as they began the lawful gun purchasing process. The ATF has said that the 4473 form, the same form that needs to be filled out for a lawful purchase, can be completed by these individuals using descriptions or directions from the nearest post office or landmark to their residence. This committee has had a number of hearings surrounding safety since this Congress began, yet this bill would take away a process law enforcement uses to keep us safe. My amendment is a study. It is just a study to review the effects this law will have on our police and our safety. And I urge you all to vote to incorporate this amendment, and I yield back.
The gentlelady yields back.
Withdraw the point of order.
Point of order is withdrawn. The gentlelady from Wyoming is recognized.
I'm going to respond to several of the statements that have been made today by both the ranking member as well as the gentlelady in support of her amendment. The ATF guidance only allows for the purchase of a firearm if the state the buyer is in recognizes a P.O. box as a lawful residence, but not all states recognize a P.O. box as a lawful residence. That also recognizes that there's no reason for a study because we haven't seen an explosion of the type of nefarious conduct as just relayed in those states that actually do recognize the P.O. box as a lawful residence. The firearms buyer must have an identification document issued by the state their P.O. box is in, and restricting the freedom of RV living and forcing spouses of U.S. military personnel to obtain new driver's licenses in every state they're stationed in is just not appropriate. Law enforcement officers can already track firearm purchases through NICS, credit card data, cell phone pings, and other techniques. This legislation will not make it more difficult for law enforcement personnel to locate firearms buyers. And in addition, in talking about other IDs and efforts to use straw purchasers and things like that, if someone fakes an ID and passes an NICS check to buy a firearm from for another person, they should face charges as a straw purchaser. Further, they should be prosecuted for lying on the ATF 4473. Instead of creating more laws, we should reinforce existing ones and hold criminals accountable. And finally, this legislation enables and codifies the ability of military personnel and their spouses, frequently relocated every 24 months, to exercise their Second Amendment rights by simplifying the process of purchasing firearms, despite challenges in establishing residency and obtaining new IDs under current ATF requirements. The fact is that this bill just merely codifies and clarifies existing ATF guidance. And finally, at a time when we're seeing rising crime and prosecutors refusing to prosecute, people need to be able to defend themselves. And there's probably nobody who's more vulnerable than those who live in the RV setting. So with that, I would urge my colleagues to support this bill and reject the amendment. Thank you. And I yield back.
Gentlelady yields back. For what purpose does the gentlewoman from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is recognized.
I thank you, Mr. Chairman. I rise in support of my colleague, Ms. McBath's amendment. It is a common-sense, logical amendment. What it does is create a study, but importantly, what it does is take out something that is extraordinarily illogical. If you see in the underlying bill, Section 2, definitions around state of residence, there is little 3I. In the case of an individual who does not have a physical residence in any state, the state in which an individual maintains a private mailbox or post office. Let's be clear. That is not a residence. That's not a state of residence. People live at residences. And so a P.O. box is a very dangerous move. I'm troubled that the bill would allow the use of a P.O. box to just prove state of residency rather than a physical address when purchasing a firearm from a federally licensed firearm dealer. It will seriously hurt law enforcement's ability to trace guns at a crime scene to a person at a physical address. What are they to do? Go visit the P.O. box and make some inquiry? There is no inquiry to be made. Criminals know about such loopholes, like the private sale loophole, and they exploit them. We are all too familiar with this problem in my home state of Pennsylvania, where the private sale of long guns costs lives. Private sale of long guns in Pennsylvania requires no background check. When we do it that way, when we allow more and more guns to come onto the street without any ability to trace, we are actually costing lives. I do support the other piece of this bill that is in support of our armed forces. That is a worthy pursuit, but this P.O. box risk is just far too great. It is critical that we protect law enforcement's ability to effectively trace crime guns to physical locations. When lives are on the line, is a physical address really too much to ask? With that, I yield back.
The gentlelady yields back. For what purpose does anyone seek to be recognized? Gentlelady from Pennsylvania, Ms. Scanlon.
Thank you. I move to strike the last word.
Gentlelady is recognized.
So in my district and communities across the country, our communities are in pain because too many people have lost loved ones, children, neighbors, and friends to gun violence. Every day, my constituents reach out to me in my office calling on Congress to pass common sense and constitutional gun legislation that would promote responsible gun ownership and keep guns out of the hands of dangerous individuals who we all agree should not have them: violent criminals, terrorists, children, and others. That's not what this bill would do. While I certainly appreciate the portions of the bill that would ease some of the burden on our military families, the P.O. box provisions here would make it easier for dangerous individuals to evade state gun laws, to stockpile weapons, and to evade background checks. These are the kinds of loopholes that we need to close, not create more of. Rights come with responsibilities, but the gun lobby and its political allies would rather perpetuate a twisted version of the Second Amendment, devoid of any responsibility at all. So we should be passing policies to make our country safer and give our children a brighter future, and this does not meet that goal. I oppose this bill and I yield back.
Gentlelady yields back. The gentleman for New York is recognized.
Thank you, Mr. Speaker. I would like to support this bill, as I said before, but it has to be amended, the way Ms. McBath said. Now, in many states, including South Dakota, you can buy a firearm from a private seller without providing a physical address, without providing ID, and without answering a single question. Now, why can you buy it from only by providing a P.O. box? But why only a P.O. box? Everybody lives somewhere. And if you required that the location of the person's residence be listed, then when and if that weapon is used in a crime, you can trace it and maybe trace the criminal. If you provide only a P.O. box, you cannot do that. So we should close this loophole. Now, Congresswoman McBath's amendment removes this provision, removes the P.O. box provision, would require a residence to be stated, and would require a study of the effects that this might have on law enforcement. But again, how can you oppose requiring someone who buys a gun to provide his address or her address? Nobody lives in a P.O. box. Everybody has a residence somewhere, and that ought to be provided. It's common sense. And not to do so is very dangerous and will lead to more criminals committing crimes with guns and not being apprehended because you can't trace them. And therefore, I support the amendment, and I yield back.
Gentleman yields back. Does anybody else seek recognition? The gentleman from Texas, for what purpose do you seek recognition?
Mr. Chairman, I seek recognition to just make a couple of comments. Let me move to strike the last word.
Gentleman is recognized.
Mr. Chairman, when the other side of the aisle says everybody lives somewhere, I know a lot of folks, frankly, that only live in their RV and it moves from location to location. That's why the P.O. box is necessary. A lot of folks do this for years on end. And so this amendment is absolutely necessary. And I'll give one specific example. In my hometown of Tyler, Texas, years ago, the chief of police retired. He and his wife sold their property, bought an RV, and traveled for a number of years before coming back to East Texas. So that's just one of many examples. I would yield the remainder of my time to the gentlelady from Wyoming.
Gentlelady is recognized.
Thank you. The amendment that has been introduced does absolutely nothing to address the issue at hand, which is to ensure the protection of our Second Amendment rights for our military personnel and those who are living in non-traditional situations. I ask unanimous consent to submit 2 articles into the record. One is by the Washington Post from November 2018. It's entitled 1 Million American Lives in RVs Meet the Modern Nomads. And then also the second one is from April 21, 2022, and it's about a bill to let modern nomads use P.O. boxes on ATF Form 4473. I will repeat what I said earlier, which is
Without objection.
Thank you. Law enforcement officers can already track firearm purchases through NICS credit card data, cell phone pings, and other techniques. This doesn't change that fact. This just merely allows the use of P.O. boxes to be used on the form so that these law-abiding citizens are able to exercise their Second Amendment rights. I realize that my colleagues on the other side do not like the Second Amendment and the protections that it provides, but as our courts have repeatedly held, it is as important as any one of the other Bill of Rights, the other natural rights that we have. It is important that we protect the individuals who don't live in the traditional settings where they have a permanent residence, but they still need to be able to protect themselves. And again, when we've got prosecutors throughout many blue states who are refusing to prosecute, people need to be able to protect themselves. So with that, I urge the rejection of the amendment and a vote in favor of the underlying bill. Thank you. I yield back.
Ada yields back. Does the gentleman from Texas?
I yield.
Gentleman yields. Anybody else seek recognition? Gentleman from California.
Mr. Chairman, I have an amendment at the desk.
Oh, we're
Okay.
anyone else seek recognition? Gentleman from Texas, Mr. Roy.
Move to strike the last word.
Gentleman is recognized.
I speak in opposition to the amendment and in support of the underlying legislation. The people I represent, the people of Texas, people across this country are increasingly put in danger as a direct consequence of the federal government inaction to secure the border of the United States, to protect their freedoms and protect the ability of the American people to defend themselves. It's critically important that our constitutional right to keep and bear arms not be interfered with paperwork and other burdens that frankly need to be lessened even more so than even this amendment does. The fact of the matter is that constitutional right exists so that individuals can be able to take care of themselves, protect themselves from dangers, including and up to the government itself, but certainly the individuals that are on the loose as a result of the government failing to do its constitutional duty to defend the people, defend the country. That's what's happening. It's happening right now in the people of Texas. This administration is suing to try to stop the people of Texas from doing what they need to do to secure the border. So the last thing I want to see is the inability of the American people to be able to have firearms, to be able to defend themselves when the federal government itself is not just at odds, but at war with the very well-being, freedom of the American people. So I think this legislation is important. I think we need more legislation like it. I think we need the full constitutional recognition of the right and the ability to be able to keep and bear arms so that we can defend ourselves when the federal government refuses to do so. Yield back.
Gentleman yields out back. Who seeks recognition? Chair recognizes himself for the purpose of striking the last word. Been through a lot of gun conversations in this committee over the years and been a part of them, and I think one of the things that we fail to recognize is how different things are in rural America. The ATF recognizes it. The ATF has been advised that a number of states issue driver's licenses with only a P.O. box or a rural route number as the residence for a holder. ATF has also been advised that persons in rural and undeveloped areas may only have a P.O. box or a rural route number as their legal address. Transient populations, often lower income, switch apartments very often. Unfortunately, military personnel, we've heard that. Tribal communities in both South Dakota and North Dakota. We're working on getting more and more, but we live in a very rural place. When you say everybody lives somewhere, that is absolutely true, but some of them don't have addresses. And in places where I live, people do not have addresses. They still have to fill out a form. They still run ATF background check, still run a NICS check, still can't be addicted to drugs or alcohol, cannot have renounced their U.S. citizenship. All of the same questions that are on every FFL form still exist, but you're accounting for a segment of the population that either lives in a place that hasn't gotten there yet or simply is transient or serving our country in the military. None of those other things go away when you buy a firearm from someone with an FFL license. And indeed, that background check has to be cleared before you can sell or purchase that license. We are simply accounting for a segment of the population that doesn't live in Chicago or Minneapolis or Manhattan, but they might live 35 miles away from the closest town, who, by the way, that closest town may only have 100 people. These are varying different places, and we all live in different communities. But what we do know is the federal background check is run uniformly on everyone. All you have to do is be able to prove you're a resident of a state. And in states like mine and in states like South Dakota, sometimes the only way you can do that is with a rural route address or a P.O. box. This is a common sense bill for people who don't necessarily live in the same places that we all consider. And I oppose the amendment and I support the underlying bill. I yield back. Or I would yield to the gentlelady from Wyoming.
Thank you, Mr. Chairman. It's ironic that you say that because I happen to be one of those people who grew up in a rural area. And in fact, my address when growing up was Fort Laramie, Wyoming. We didn't have a P.O. box. We didn't have any kind of an address. We lived 5 miles outside of the closest town of 350 people. And everybody within the entire community, that was their address, was just merely Fort Laramie, Wyoming. There was no other identification of what our address was. I just received some letters from my 100-year-old mother, and the address is Fort Laramie, Wyoming. And so it is ironic that you say that. With that, I yield back. Thank you.
Thank you. And I will say, as somebody who used to drive from Dickinson, North Dakota to Gillette, Wyoming to coach American Legion baseball, it is definitely God's country, but at certain points in time, you think you're on the surface of the moon. I yield back. Who seeks recognition? Seeing none, the question occurs on the amendment offered by the gentlelady from Georgia. Those in favor say aye. Aye. Those opposed say nay. No. In the opinion of the chair, the noes have it. Roll call vote's been requested. Clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Buck. Mr. Gates. Mr. Biggs. Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes no. Ms. Sparts. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Bentz. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Armstrong votes no. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Ms. Hageman. No. Ms. Hageman votes no. Mr. Moran. No. Mr. Moran votes no. Ms. Lee. Mr. Hunt. Mr. Fry. No. Mr. Fry votes no. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Ms. Ballant? Ms. Ballant votes aye.
How's the gentleman from Florida recorded?
Mr. Gates votes no.
How's the gentleman from California recorded?
Mr. Kiley votes no.
Have all members voted? Does any member wish to change their vote? Clerk will report.
Mr. Chairman, there are 12 ayes and 12 noes.
The amendment is not agreed to. Who seeks recognition? The gentleman from California, Mr. Schiff.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Jennifer from California reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 1508 offered by...
Without objection, the amendment will be considered as read. The chair now recognizes the gentleman for California to explain his amendment.
Thank you, Mr. Chairman. This amendment would add the Bipartisan Background Checks Act of 2023, authored by Republican Brian Fitzpatrick, to the underlying bill. This would provide universal background checks. We live in a state, live in a country where you can go into a gun store, you can be a felon, or you can have a serious mental health issue that should disqualify you from obtaining a weapon. You can have a domestic violence restraining order against you, and you can seek to purchase a gun, and you can be refused. But you can leave that gun store, you can go outside, you can buy that same weapon off the back of someone's truck. Or you can buy it online. Or you can buy it at a gun fair. It makes no sense to have a situation in this country where you can be refused because you failed a background check when you go to a store, but you can leave the store and buy the same weapon in the parking lot. That makes no sense to anyone, except perhaps the NRA. We don't have to live with the constant scourge of gun violence. We don't have to live every day just a phone call away from getting terrible news that someone in your family has been killed. Like so many families, my wife and I got a call from one of our kids about a shooting not far from campus. He was fine. Thank God he was fine, sheltering in place, but so many others have gotten much worse calls. And they're going to continue to get those calls if we don't do something about this. And the terrible shame about gun violence is it's not like we don't know what works. We know universal background checks work. We know an a ban on assault weapons works. We know a ban on extended ammunition clips would work. We just have lacked the political will and courage to get it done. My constituents want universal background checks. This amendment would provide universal background checks. Your constituents, my friends across the aisle, they want the same thing. Americans overwhelmingly want truly universal background checks. Now, I realize the NRA doesn't want it, and so this puts all of us in the position of, are we going to vote for our constituents or are we going to vote for the NRA? Well, I'm voting for my constituents. I'm voting for people in my home state of California who are sick of the constant scourge of gun violence, who are fed up with a Congress unwilling or unable to do anything about it. It makes no sense to have a system where you walk into a store and you're refused a gun because you're a felon and you can go outside and you can buy the same gun off the back of someone's truck. That makes no sense. This amendment gives us a chance to change that. Gives us a chance to do something about this terrible, all-too-American problem of mass gun violence and everyday gun violence. Can we please do something? Protect the lives of our family and our neighbors. Protect the lives of people in their churches and their synagogues. Can we please just do something basic? Something simple, something universal, something that makes sense. I urge support of the amendment, and I yield back.
Gentleman yields back.
I withdraw the point of order.
Gentleman withdraws a point of order. Who seeks recognition? Gentlelady from Wyoming.
Move to strike the last word.
The gentlelady is recognized.
And I think that we've already covered the purpose of this bill and why it is needed, and the fact that we're talking about law-abiding citizens who both those in the military as well as those in non-traditional living arrangements. It's called the Travelers Gun Rights Act of 2024. We need to focus on what the purpose of the bill is. Anytime that a Democrat starts talking about universal background checks, you know that it's just another effort at gun grabbing and preventing people from being able to exercise their Second Amendment rights. I think that the bill is very clear. This is just another effort to prevent us again from being able to, a certain segment of our population, a certain segment of our law-abiding population from being able to exercise their rights. There are already laws in place for people who are straw purchasers or who are failing to follow the current gun laws. And instead of creating more laws, we should simply enforce the existing ones that are on the books and actually hold criminals accountable. With that, I urge rejection of this amendment and a yes vote on the underlying bill. Thank you. And I yield back.
The gentlelady yields back. For gentleman from New York. For New York, what purpose does he seek to be recognized?
Strike the last word.
The gentleman's recognized.
Mr. Speaker, I rise in support of this amendment. It is a terrible exception that you can buy a gun from anyone who's not a licensed dealer with no background check. Anybody can get the gun. Any bank robber, any serial murderer can walk in and ask for a gun, no questions asked. That makes no sense at all. From a private seller, that's what I said. From a private seller, not a licensed gun dealer. That makes no sense at all. This country has more gun deaths, I think 45 times as much per capita as any European country, because of loopholes like this, because of obeisance to the NRA. This is a modest amendment. All it does is say you have to have a background check, the same background check you'd have if you bought a gun from a licensed gun dealer, if you buy a gun from an unlicensed gun dealer. Why could anybody object to that? I urge adoption of the amendment, and I yield to Mr. Schiff.
I thank the gentleman for yielding, and I do want to respond to my Republican colleagues' comments. First of all, when you say any time a Democrat offers a universal background check amendment just because they want to take away people's guns, this is actually language written by a Republican from Pennsylvania. But even if it weren't written by a Republican, what about the rights of a middle school kid or an elementary school kid to go to school and not be gunned down with an assault weapon? What about their rights? What about the rights of worshipers in their place of faith not to be gunned down because someone could evade a background check by buying it at a gun show or buying it off the back of someone's truck? What about their right to life, to liberty, to the pursuit of happiness? Does that get no weight at all? And all we are asking is that people go through a background check before they acquire a record. Is that too much to ask for that child's life in grade school? Or that worshiper's life in church, or a moviegoer's life in the movie theater? Is it too much to ask that we make sure that people aren't circumventing the law by making background checks truly universal and not just a fractured system in which there are an infinite ways to avoid any kind of scrutiny? I don't think it's too much to ask, and I think we need to consider the rights of every American, including gun-owning Americans, not to be gunned down in their everyday lives because someone evaded a background check by buying the gun at a gun show or buying it online. It doesn't seem too much to ask to take this simple step if it's going to save so many American lives. I yield back.
And I yield back.
Gentleman yields back. Who else seeks recognition? Gentleman from Georgia, Mr. Johnson.
Thank you. I rise in full support of this very common sense amendment. I'll note, being from Georgia, that when I go home from the airport, I'll take the highway on home, and along the highway, the interstate, there will be billboards advertising for the next gun show coming to Georgia, coming to the metropolitan Atlanta area. And so I've had the opportunity to actually go to the gun shows, and I've been to the gun shows on the north side of town. I've been to the gun shows on the south side of town. And in every gun show, I see young urban residents purchasing guns from gun dealers, from licensed gun dealers, and also from unlicensed gun dealers. The tables will be set up in the gun show. There will be licensed gun dealers, and right next to the licensed gun dealer, an unlicensed gun dealer, and the setups are the same. I mean, you got tables, display cases. You can't really tell the difference, but the people there who come to make the purchases know the difference. And they will go to either a licensed gun dealer if they're legit, if they themselves are legitimate, and if they're not, then they make their way to the unlicensed gun dealer who's carrying the same wares as the licensed dealer, and they make their purchase from the unlicensed gun dealer. And then they walk out, and then they commit, those guns are used to commit crimes in urban and suburban areas that I represent. And those guns also make their way up here to Washington, D.C., and to other places with tighter restrictions on guns. And I don't know why we have a system of licensed gun dealers. I mean, there had to have been a reason why we originally licensed or we originally set up a regime whereby gun sellers had to be licensed. There was some usefulness in that setup, but the NRA came along and voila, a loophole inserted to allow unlicensed gun dealers. That undercuts the reason why you would have licensed gun dealers. The reason or the rationale for licensed gun dealers still exists today, and we need to go back to that system. We need to close this gun show loophole that allows for gun sellers to sell guns to anybody without a background check. It just simply leads to where we are today, which is too many firearms in the hands of too many people who should not have them. And with that, I will yield back.
Gentleman yields back. Who seeks recognition? The gentleman from New Jersey, Mr. Van Drew.
Just quickly on guns, you know, it's interesting to me that the areas where we have the most problems tend to be some of the areas that have the most strict and prohibitive legislation, laws, and rules dealing with them. I mean, I don't know what we don't understand, but we keep creating more laws, more rules, more regulations for those that are legal owners. Now, here's the deal. It's not the legal people that we have to worry about. We have two issues with guns. The first issue is that we have a real mental health crisis in this country. And I honestly believe, sincerely, part of that is due to the breakdown of the family, due to the stress and problems that exist in today's modern society, and just a lack of the basic values that we've held for so long. You know, when you look at these mass shootings and some of the horrific things that happen, almost all of those individuals put out in one way or another cries for help. They let people know. There were reports to the FBI, there were reports to others, and yet nothing happens so often. That's where we need to do better. And then the second issue is the rule of law. The rule of law. You know, when I was in the state senate in New Jersey, and a nice person, and I'm obviously not going to say who it was, they were just passing another rule and another regulation and another law going after law-abiding, peaceful gun owners. And, you know, she was trying to convince me that this was a good thing to vote for. And I think we had a good, thorough discussion about it. But towards the end of it, she said, you don't understand, this person who did this, who was a criminal, was using a legal gun. She said the only difference was they scratched the numbers off the gun. It wasn't a legal gun. That's what we have to do. We need the rule of law. Those that would steal guns, those that would get them in an illegal way is where the concern should be. What's happening to our urban areas, the lack of respect for the law, the complete decay of so many of our cities and the increase in the crime rate, it's got nothing to do with the individual man or woman that goes target practicing, that goes hunting, that uses guns in a legal way. And it just gets old. So we keep passing more and more laws prohibiting more and more legal people that do no more harm, and yet we don't do enough. And in fact, we're doing less. You know, in so many of these areas, quite frankly, with liberal prosecutors, they let people out quicker than we ever did before. They commit a crime, they turn around, they're right out. I've talked to police officers in Washington, D.C., and they said it's to the point where we're told if it isn't a homicide and we don't hear gunshots, we don't even do anything anymore. But even when it is, they're turning people out more quickly. We all saw in D.C. when they wanted to actually let people out more quickly and reduce the penalties for carjacking. We realized in Washington, D.C., that we had an FBI agent whose car was jacked. We had staff people working for senators and Congress whose cars were carjacked at gunpoint, that we've had others, Congress, members of Congress, including a Democrat congressman, that were carjacked. It's all because we don't have the rule of law. We could fix this real easily. Better mental health and better rules and laws dealing with those who are illegal, those who are criminals. All those carjackers, they didn't go and get their gun registered. They didn't go through a process where they got qualified to carry a gun, as legal people do. So, what we'll probably do is make it harder for, good American people that aren't doing anything wrong to get a gun or to get ammunition. That's not the problem. I yield back.
Gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Just in response to my colleague's comments, as someone who has been carjacked and was carjacked by people who were 17 and 19 years old and had obtained illegal guns because our streets, our entire country is awash in guns that people are making in their homes because we're not regulating ghost guns that are coming up the iron pipeline. There's a term for it that our law enforcement talks to us about. The iron pipeline from the southern states up the I-95 corridor and even smuggled on Amtrak to come up to cities like Philadelphia, to be trafficked to children who then use them in carjacking. So I do think we need to pass some laws. You say we've passed a lot of laws. In fact, they haven't become laws. We need more legislation that can be enforced to make sure that when people exercise Second Amendment freedoms, which I don't think anyone on this side is saying we got to take everyone's guns away, but we are saying that if you're going to own a gun, you need to do so responsibly. That's what my family grew up with in a rural area. I assume that Ms. Hageman's family had responsible gun ownership. They weren't just throwing them out on the street or selling them for a couple $100 to whoever happened by. I think we need to make some distinctions here. It is not a black or white issue.
Will the gentlelady
Like
yield
every
for a
other.
moment?
No, I'll yield back to the chair.
Gentlelady yields back. Gentleman from Wisconsin is recognized.
Move to strike last word.
Gentleman's recognized.
I would yield my time to the Congresswoman from Wyoming.
Thank you. Move to strike the last word.
Gentlelady is recognized.
All right, let's go back to what the purpose of this bill is, because we've moved way far astray. I'm going to say this again. H.R. 1508, the Travelers Gun Rights Act of 2024, is a simple and straightforward bill that allows active duty service members, their spouses, full-time RV travelers, and those without a permanent resident or address, such as what we've described in rural America, to legally purchase firearms with either a private mailbox or a post office box number. We are now addressing an entirely different set of legal and criminal issues that has nothing to do with the question of whether that subset of people should be able to use a private mailbox or a post office box number for their address to purchase a gun. And unless you can point to this particular subset of people being the perpetrators of the crimes that you have described, which I'm sure that the 17-year-old and 19-year-old involved in that crime that you have described were not living in RVs, were not the spouses of active duty service members, and were not themselves active duty service members, the same can be said for the people involved in the other types of criminal acts that you have described. Unless you can say that those are the ones that are the subject of this bill, then everything you have described is entirely irrelevant to the topic at hand. This is not about yet another effort at gun grabbing. This is about making sure that a particular subset of law-abiding citizens are able to exercise their Second Amendment rights. With that, I would yield to the gentleman from New Jersey.
Thank you, I appreciate it. And you're right. You're obviously right about what you just said. And unfortunately, it was addressed on the other side. And a problem I have, I guess it's from being from New Jersey. I can't let stuff go sometimes. But this is a subject of the bill. It's a good bill. it's appropriate. And I guess my point would be, again, those people who are service members, those people who are living in rural areas or live in RVs or whatever the case may be, are not the problem here. And I believe that's what the gentlelady is pointing out. And in general, the gun issue is not the problem, is not those who legally obtain guns. There's no reason that these people can't obtain guns as well just because of their particular address. And I know in some rural areas, even in my part of New Jersey, there are folks that have P.O. boxes that are great individuals and great human beings and don't deserve to be discriminated against in this case. I yield back.
Gentlelady yields back, and the gentleman from Wisconsin yields back. Who seeks recognition? Chair recognizes himself for 5 minutes. I do think there's one place where this amendment is relevant to the underlying bill, and it is where the same people charged with enforcing this, which would be the federal government, are the same people who wrote it, and it's abundantly clear they don't understand rural America. The exceptions that are written allow for a federal government on interpretation of state law, whether it's farming law, whether it's domestic violence law, whether it's hunting, fishing, trapping laws. And it puts a tremendous burden shift on a citizen exercising their Second Amendment rights to qualify that they have the ability for a temporary transfer. First of all, there are no shooting galleries in North Dakota. I think you'd get beat up if you said the word shooting gallery in North Dakota. The vast majority of people who do these types of things in rural America do them in rural areas, on farms, on different places. But the audacity or the ability to temporarily do this with hunting, fishing, farming, ranching, and to be, in order to engage in your lawfully protected Second Amendment activity, you have to essentially vouch for compliance with every single state law that you may come into contact. Give you an example. North Dakota, you have bifurcated farmland. So if you're engaged in farming and you borrow your truck to your ranch hand that has a gun in the back, and you drive to town and have breakfast before you go check cows south of town, when you leave the ranch, you're probably engaged in farming. When you get to the place, you're probably engaged in farming. But when you stop at that town with that gun in the back of your car rack, as you borrowed the ranch owner's hand, you're not engaged in farming or ranching. You're having breakfast. And to say that the federal government has primacy in prosecution over that state law in all of these different situations that, by the way, happen every single day in rural America, every single day. But it's more draconian than that, and it's more nefarious than that, because the people I know are lawful gun owners. It doesn't matter if you're a hunting buddy or a hunting guide or a fishing guide or a farmer or a rancher. When you have the ability to the federal government to come in and prosecute based under intent by a transfer for temporary transfer, in utilizing state law to incorporate a federal charge, you are just going to see these things not happen because these people want to follow the law. They are law-abiding citizens. And so when I read these things and I read how the exemptions are written, and I appreciate my friend Mr. Fitzpatrick, and I appreciate people who care about this, but is it abundantly clear to me that the vast majority of the people who write these exceptions for rural America have never been anywhere farther than wherever their local city park is. And until we recognize that this is not how life occurs in places where I live and where Ms. Hageman lives and where Mr. Johnson lives, which is the same reason for the underlying bill, by the way, then you are dealing with issues that simply do not work in huge swaths of this country. And for that reason, I would oppose the amendment and I would support the underlying bill. And with that, I yield back. Question occurs on the amendment from the gentleman from California. All those in favor say aye. Aye. All those opposed say nay. No. In the opinion of the chair, the noes have it.
Mr. Chairman, on that, I request to record a vote.
A roll call vote has been requested. Clerk will call the roll.
Mr. Jordan, Mr. Issa, Mr. Buck, Mr. Gates, Mr. Biggs, Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany votes no. Mr. Massey, Mr. Roy, Mr. Bishop, Ms. Spartz, Mr. Fitzgerald, Mr. Bentz, Mr. Klein, Mr. Armstrong. Mr. Armstrong votes no. Mr. Gooden, Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels, Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Ms. Hageman votes no. Mr. Moran. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Fry votes no. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson. Mr. Johnson votes aye. Mr. Schiff. Mr. Schiff votes aye. Mr. Swalwell. Mr. Liu. Mr. Liu votes aye. Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. McBath votes aye. Ms. Dean. Ms. Escobar. Ms. Escobar votes aye. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Klein. Mr. Klein votes no.
How's the gentleman from Florida recorded?
Mr. Gates votes no.
Is Ms. Dean recorded?
Ms. Dean, you're not recorded. Ms. Dean votes aye. Mr. Correa, you are not recorded. Yes. Mr. Correa votes yes. Mr. Fitzgerald, you're not recorded. Mr. Fitzgerald votes no.
How's Mr.
Mr. Moran, you are not recorded. Mr. Moran votes no.
How's the gentleman from North Carolina, Mr. Bishop, recorded?
Mr. Bishop votes no.
How's Chairman Jordan recorded?
Chairman Jordan's not recorded. Chairman Jordan votes no.
Have all members voted? Anybody wishing to change their vote? Clerk will report the roll.
Mr. Chairman, there are 14 ayes and 14 noes.
The amendment is not adopted. Who seeks recognition? The question. There we go. The question occurs on in the amendment in the nature of a substitute. All those in favor say aye. All those opposed say no.
No.
In the opinion of the chairs, the ayes have it. Roll call. For the ANs? A reporting quorum has been being present. The question is on favorably reporting the bill as amended. All those in favor say aye. All those opposed say no. In the opinion of the chair, the ayes have it. A roll call vote has been requested. The clerk will call the roll.
Mr. Jordan. Mr. Jordan votes yes. Mr. Issa. Mr. Issa votes yes. Mr. Buck. Mr. Gates. Mr. Biggs. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes aye. Ms. Sparts. Mr. Fitzgerald. Mr. Bentz. Mr. Klein. Mr. Armstrong. Mr. Armstrong votes yes. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes yes. Mr. Nels. Mr. Moore. Mr. Moore votes yes. Mr. Kiley. Mr. Kiley votes aye. Ms. Hageman. Ms. Hageman votes aye. Mr. Moran. Mr. Moran votes yes. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Fry votes aye. Mr. Nadler. Mr. Nadler votes no. Ms. Lofgren. Ms. Lofgren votes no. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson. Mr. Johnson votes no. Mr. Schiff. Mr. Schiff votes no. Mr. Swalwell. Mr. Swalwell votes no. Mr. Liu. Mr. Liu votes no. Ms. Jayapal. Mr. Correa. Mr. Correa votes no. Ms. Scanlon. Ms. Scanlon votes no. Mr. Neguse. Ms. McBath. Ms. McBath votes no. Ms. Dean. Ms. Escobar. Ms. Escobar votes no. Ms. Ross. Ms. Ross votes no. Ms. Bush. Mr. Ivy. Mr. Ivy votes no. Ms. Ballant. Ms. Ballant votes no. Ms. Jayapal. Ms. Jayapal votes no. Mr. Fitzgerald. Mr. Fitzgerald votes aye.
How's Mr. Gates recorded?
Mr. Gates is not recorded. Mr. Gates votes aye. Ms. Dean, you're not recorded. Ms. Dean votes no.
How's Mr. Klein recorded?
Mr. Klein, you're not recorded. Mr. Klein votes aye.
How's the gentlelady from Texas recorded?
Ms. Jackson Lee is not recorded. Ms. Jackson Lee votes no. Mr. Gates, you're recorded as aye.
How is Mr. Neguse recorded?
Mr. Neguse is not recorded. Mr. Neguse votes no. Mr. Roy, you're not recorded.
Yes.
Mr. Roy votes aye.
How is Mr. Benz recorded?
Mr. Benz, you're not recorded. Mr. Benz votes yes. Ms. Bush, you are not recorded. Ms. Bush votes no. Mr. Massey, you are not recorded. Mr. Massey votes yea.
The gentlelady from Florida recorded.
Ms. Lee, you are not recorded. Ms. Lee votes aye.
Have all members voted? Clerk will report.
Mr. Chairman, there are 19 ayes and 18 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes.
Pursuant to notice, I call up H.R. 5585, the Agent Raul Gonzalez Officer Safety Act for purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 5585 to impose criminal and immigration.
Objection, the bill be considered as read and open for amendment at any point. Chair now recognizes himself for an opening statement. The Biden border crisis continues unabated. Since President Biden took office, and due to his policies, more than 7 million illegal aliens have been encountered along the southwest border by U.S. Customs Border Protection. That does not even include the 1.7 million known gotaways or the unknown number of unknown gotaways that have evaded Border Patrol agents and escaped into the U.S. Because of the Biden administration's open borders policies, human smuggling is now more lucrative than ever. In fact, earlier this month, Border Patrol agents told members of this committee during the Speaker's Codel to Eagle Pass, Texas, that in the Del Rio sector alone, cartels make $32 million per week off human smuggling. $32 million per week. That's $1.6 billion per year in just one sector on our southern border. Open borders embolden criminals. High-speed chases with smugglers occur daily in border communities, placing both law enforcement officials and American citizens at risk. Sadly, there are too many tragic examples to count. Just 2 days ago, criminals led Texas Department of Public Safety officers on a high-speed chase outside of Del Rio, Texas, as they attempted to smuggle half a dozen illegal aliens into the interior of the country. At least one of the smugglers was himself a foreign national from Nicaragua. Amazingly, this criminal alien had been granted work authorization by the Biden administration in October. Last February, Cochise County, Arizona Sheriff Mark Daniels, a 38-year veteran of law enforcement, testified before this committee at our first hearing on the Biden border crisis. Sheriff Daniels told us about a woman from his county named Wanda, who was killed on the way to her 65th birthday party. She had hoped to enjoy some time with her son, who was receiving treatment for stage 4 cancer. According to the sheriff, the criminal who caused the crash was smuggling illegal aliens when he fled from law enforcement officers, blew through a red light, and crashed into Wanda's car, cutting it in half and instantly killing her. These dangerous car crashes don't kill just everyday Americans. They kill our law enforcement heroes, too. While on duty in the Rio Grande Valley sector in South Texas last December, Border Patrol agent Raul Humberto Gonzalez Jr. was killed while pursuing a group of illegal aliens who were evading Border Patrol. During the pursuit, Agent Gonzalez crashed his ATV into a gate. He succumbed to his injuries just hours later. Authorities do not have the tools to fully prosecute and punish these criminals. Currently, the failure to yield to a Border Patrol agent or other law enforcement officer assisting Border Patrol is not explicitly criminalized under federal law, nor does it carry specific immigration consequences. In other words, criminals and foreign nationals have little incentive not to evade Border Patrol agents. Let us be clear. These bad actors must be held accountable. H.R. 5585 does just that. The Agent Raul Gonzalez Officer Safety Act ensures that those who endanger border communities by failing to yield to Border Patrol agents will face meaningful consequences, ensuring aliens who endanger American communities can be prosecuted and ineligible for certain immigration benefits under our laws. I want to thank Arizona Representative Juan Ciscomani for his leadership on this bill. It's time we stood strong against the criminals who cause fear, devastation, and harm to our law enforcement officials and to people in our border communities. With that, I would yield back and now recognize the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 5585, the Agent Raul Gonzalez Officer Safety Act, would establish harsh criminal and immigration penalties for flight while operating a motor vehicle from a pursuing U.S. Border Patrol agent or other law enforcement officer assisting in that pursuit. To begin with, let me be clear that the death of Agent Gonzalez in the performance of his duties is a tragedy, and our hearts go out to his family and friends. I appreciate the sentiment behind honoring him through legislation. But H.R. 5585 is not the best or even a viable answer to the perceived problem giving rise to this bill. The most aggressive immigration enforcement tactics are often employed in the border region of the United States, including high-speed vehicle pursuits. And the risk inherent to such vehicle pursuits is borne most heavily by migrants, civilians, and innocent bystanders. As our colleague Representative Escobar has previously pointed out, these chases can be incredibly dangerous, often ending in horrific accidents with serious injuries or even the deaths of individuals being chased by law enforcement. The number of fatalities resulting from Border Patrol vehicle pursuits grew from 2 deaths in 2019 to 22 deaths in 2021. In the subsequent 2-year period, 44 people were killed in these pursuits. The deadly consequences of vehicle pursuits have been well documented by advocacy and civil rights organizations, particularly the ACLU of Texas and the ACLU of New Mexico. According to the CBP Fatal Encounters Tracker maintained by the ACLU of Texas, Border Patrol-involved vehicle pursuits resulted in 107 deaths not including law enforcement officers, between January of 2010 and November of 2023. Following public outcry as the number of deaths continued to rise, and the urging of members of Congress, including Representative Escobar, CBP conducted a review of its vehicle pursuit policy. The review resulted in a newly revised directive published in January of last year, just 1 month after Agent Gonzalez was killed. The net effect of the new policy is to discourage the number of high-speed pursuits. Let me be clear. My concern about the possibility of harm from hot pursuits extends both to law enforcement, the CBP officers working every day to secure our borders, and the public at large. Statistics have shown that high-speed chases have historically been one of the leading causes for law enforcement fatalities. When weighing the potential risks to the safety of the public and law enforcement officers, many jurisdictions have determined that the risks are far too great to justify a vehicle pursuit. That is why we should be careful that we do not, through this legislation, appear to encourage Border Patrol agents to engage in high-speed vehicle pursuits, or for state and local law enforcement officers to look for opportunities to participate in vehicle pursuits with Border Patrol agents. Moreover, I question whether it is wise to create what amounts to a special protection or status for Border Patrol agents and outside agencies that provide assistance in a pursuit. I'm also unaware of any circumstances in which a federal officer could give commands or orders to a state or local officer other than when state and local law enforcement officers serve in a federal task force. In addition to the problematic premise on which this legislation is built, I'm very concerned that this bill would require mandatory sentences of at least 5 years or 10 years, depending on whether serious bodily injury or death occurs, without requiring intent to cause injury or death. For more than a decade, mandatory minimums have been widely condemned for many reasons, including the disproportionate application in cases involving people of color and the resulting mass incarceration and over-policing of marginalized communities. We must continue to resist every urge to add to the list of federal criminal offenses subject to mandatory minimum penalties because they have served to perpetuate injustice and inequity within our criminal justice system. Turning to the immigration provisions of this bill, the justification for such harsh penalties is similarly lacking. People who are convicted of fleeing law enforcement are already deportable and inadmissible. One of the many ways someone can become inadmissible or deportable is if they are convicted of a crime involving moral turpitude, commonly called the CIMT. While the term is quite vague, courts have previously determined that knowingly fleeing or eluding law enforcement is a CIMT. However, this bill makes a significant change by not requiring that an individual actually be convicted of the crime to render them deportable. To be deportable for a CIMT, there must be a conviction. But this bill would erase that conviction requirement, allowing someone to be rendered deportable even if they have never been convicted of a crime. Being classified as deportable is not about undocumented immigrants who are, of course, already removable. And this is not about people who are seeking to enter the United States. This is about people who are already here. By and large, we are talking about lawful permanent residents, people who have put down roots in our communities, many of whom have U.S. citizen spouses and children, and who have truly established themselves here in the United States. Many of these individuals are eligible to become U.S. citizens today. If they are convicted of evading or fleeing law enforcement, they are generally already removable. Rendering such a person deportable without requiring a conviction may be a violation of their due process rights. While the inclusion of mandatory minimum sentences is enough reason to vote no on H.R. 5585, the unjustifiably harsh immigration provisions render the bill a complete non-starter, and the provision to penalize someone who is not convicted of a crime should be a non-starter. And while this legislation might be noble in its goal to memorialize a fallen CBP officer, it is both flawed and problematic in application. I urge my colleagues to vote no. Thank you, and I yield back.
The gentleman yields back. Without objection, all of their opening statements will be included in the record. The chair now recognizes himself for the purpose of offering an amendment in the nature of a substitute. Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes himself to explain the amendment. This amendment adds grounds of inadmissibility and removability to ensure aliens who evade Border Patrol officers are inadmissible to and removable from the United States. This amendment also makes clarifying changes to ensure that aliens who evade Border Patrol are ineligible for immigration relief. In addition to small technical changes, I urge my colleagues to support this amendment in the nature of a substitute and yield back. Who seeks recognition? Gentlelady from Texas is recognized.
Mr. Chairman, I have an amendment at the desk.
The clerk will report. Gentleman from California reserves a point of order. Mr. McClintock.
Amendment to the amendment in the nature of a substitute to H.R. 5585.
No objection. The amendment will be considered as read. The gentlelady from Texas is recognized to explain her amendment.
Thank you, Mr. Chairman. And as I have said many times before, I believe I'm the only member of this committee who lives on the U.S.-Mexico border. I have the incredible privilege of representing my hometown of El Paso, Texas. And before I begin to explain my amendment, I would like to enter an article into the record, and I ask unanimous consent. And the article is from El Paso Matters. DPS rammed family vehicle, pointed guns in mistaken Operation Lone Star Stop, El Paso and say.
Without objection.
Thank you so much, Mr. Chairman. I have some very serious concerns about this bill, and I appreciate the ranking member outlining the ways that communities like mine along the U.S.-Mexico border frequently are targets of these kind of high-speed chases. And in fact, as I've said many times before, in my community of El Paso, there are frequent high-speed chases by the Texas Department of Public Safety in very dense urban areas. They have caused fatalities, significant property damage, and one family, the Ayalas in El Paso, were subjected to serious civil rights violations. And while the serious concerns that I have about the bill are significant, I am attempting to address one of those concerns with my amendment. My amendment ensures that any legal permanent residents suspected of fleeing or evading law enforcement under this bill must first be convicted of a crime before being rendered deportable. While there are exceptions, the majority of deportability grounds require a conviction. The conviction requirement is there for an important reason: to protect the due process rights of legal residents. Republicans on this committee love talking about having immigrants do things the right way, but they continue to find ways to leave even those immigrants who have successfully obtained green cards vulnerable to deportation. Bills like H.R. 5855 target communities with large immigrant populations, communities where people have valid reasons to be wary of being pulled over by law enforcement or immigration enforcement, as cited in the article that I entered into the record, even those who are citizens of this country and even those with legal permanent residency status. Many legal permanent residents have lived in the United States for years, have jobs, families, and well-established communities. Many are currently eligible for U.S. citizenship, and rendering them deportable without requiring a criminal conviction raises serious due process issues. By requiring a conviction, we can ensure that anyone impacted by this law has their day in court and that due process rights are respected before we consider removing someone. I urge my colleagues to support this amendment, and I yield back.
Gentlelady yields back. Is there any discussion on the amendment? The chair withdraws a point of order and would recognize himself for 5 minutes. I need to point out, first of all, I have to look to the ranking member's argument, which I find is one of the silliest, most bizarre I think I've ever heard in the Congress. His argument against the bills is that by increasing the penalties for evading the Border Patrol, we're going to encourage more people to evade the Border Patrol. Does he really believe that by increasing the penalty against fleeing the Border Patrol, we're going to encourage that behavior? The logic behind that is pretty simple. The higher the penalty, the greater the incentive to break the law. That is ludicrous. But getting to the gentlelady's amendment, I need to point out that the Agent Raul Gonzalez Officer Safety Act requires that aliens be convicted of or at least admit to evading arrest or detention while operating a motor vehicle.
Contrary to their talking points, not every ground of admissibility and removability in the Immigration and Naturalization Act requires a conviction. In fact, the language here is identical to the grounds of inadmissibility for crimes involving moral turpitude and controlled substance offenses under INA 212A2. Even for grounds of removability, convictions are not always required. For example, an alien can be removable for overstaying his visa, violating his non-immigrant status or his condition of entry, smuggling aliens, committing marriage fraud, being a drug user or drug addict, falsely claiming U.S. citizenship, or engaging in espionage. By requiring at least an admission, this bill conforms to the pattern of other grounds of inadmissibility and removability. In this world in which the border crisis created by the Democrats has perpetuated crimes like this one, this bill seeks to punish. This bill is more relevant now than ever. And with far-left prosecutors who may never prosecute these offenses or will allow aliens to plead down to crimes that may not make them deportable, it makes no sense to strike this provision to require a conviction. If an alien has admitted to such conduct, why can't the alien's own admission be used to show that the alien is inadmissible and deportable? This amendment would strike this reasonable provision, and I'd urge my colleagues to oppose the amendment and yield back. Is there further discussion? Ms. Jayapal.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I rise in support of my colleague, Ms. Escobar's excellent amendment. I think that the chairman's comments just now are conflating inadmissibility and deportability, because right now, crimes of moral turpitude do require conviction for deportability. And that is exactly what Ms. Escobar's amendment is seeking to do, is make sure that we actually have the due process that immigrants should be allowed to have. And I'll just say I have a number of concerns with this bill, because once again, I think the majority is introducing a bill that is a solution in search of a problem. The legislation is not needed. It's overly punitive. It burdens border communities, as you just heard from my colleague, that are already fearful of Border Patrol and the impact that they have on their daily lives. The new criminal penalties in this law are largely already covered in another statute, which makes it a crime for individuals to flee or evade a Border Patrol checkpoint. According to the Government Accountability Office, there are already over 110 of these Border Patrol checkpoints, anywhere from 25 to 100 miles from the border. Evasion of these checkpoints has in the past led to dangerous high-speed pursuits. We do not need another criminal statute with another mandatory minimum sentence on top of current law. Instead, what has long been needed is policy reforms that my colleagues on the other side simply refuse to agree to. After an increase in fatalities of those being pursued during high-speed chases in 2021, CBP undertook a review of its vehicle pursuit policy. In 2023, after this detailed review, CBP overhauled its vehicle pursuit policy, adopting a, quote, objective reasonableness standard that is consistent with most law enforcement agencies across the United States. This was a very important reform, and one that I'm hopeful will better protect the safety of agents and the public. I am very concerned that this bill will further erode and create additional fear of law enforcement in border communities. Texas's new SB 4 law has already created fear among immigrant communities. Many worry that it will lead to racial profiling and will require citizens and non-citizens to carry all of their paperwork to prove that they are here lawfully or are U.S. citizens, making people afraid to leave their homes without their passports or birth certificates or Social Security cards. And that's why the legislation is opposed by the Texas Police Chiefs Association and members of the Texas Major Cities Chiefs, which includes the police chiefs in Dallas, Houston, Austin, Arlington, Fort Worth, and San Antonio. This bill's expansive nature and draconian mandatory minimums will only increase that fear and anxiety. Sadly, there have also been some horrific incidents that have left communities scared of Border Patrol agents themselves. For example, in 2014, a Border Patrol agent named Esteban Manzanares assaulted and raped a Honduran woman, her 14-year-old daughter, and another teenage girl after they surrendered themselves to him on the banks of the Rio Grande River. After raping the mother and daughter and attempting to murder them, Mr. Manzanares abducted the teenager, brought her back to his apartment where he left her bound and naked while he went to finish his shift. He killed himself before he could be brought to justice. Unsurprisingly, this incident elicited outrage and concern from the local community. One resident said, quote, "The sad truth is we're not afraid of the cartels or terrorists crossing the border in my community. We're afraid of the men in our own uniforms," end quote. After this traumatic event, it would not be unreasonable for members of the community, especially women, to be concerned for their safety when they're pulled over by Border Patrol. I don't use this example to cast aspersions on Border Patrol. We know that the overwhelming majority of agents grew up and live in border communities and are beloved members of their communities, and they serve our country every day. I use this example only to show why some members of border communities may have a legitimate fear of law enforcement, which only further highlights why, if we're going to make fleeing from Border Patrol a deportable offense, as this bill does, then we need to at least require a conviction and provide for basic due process and a day in court for people. I hope my colleagues will reconsider this unnecessary and unneeded legislation, but at a minimum, I hope that we can approve and vote through Congresswoman Escobar's amendment. I yield back the balance of my time.
The lady yields back. Is there further discussion? Mr. Biggs.
Thank you, Mr. Chairman. Move to strike the last word.
The gentleman's recognized.
Thank you. I rise in opposition to this amendment, and I do take some umbrage with taking a particularly egregious bad actor, and no matter how innocent you claim it is with regard to all the rest of the CBP agents, basically inflicting that person's horrific misconduct and criminal conduct and dangerous conduct as representing the CBP, and that's why people are afraid. But let me tell you who else is afraid. I want to tell you who's afraid. People in Arizona cities and towns and in their counties. I'm thinking of Cochise County, where you have one municipality that has at least 2 high-speed chases a day. They average 2 high-speed chases a day and have had multiple crashes, including fatalities. And what is happening is this recruitment of these drivers that the cartel engages in. They're using social media to recruit youthful drivers out of Phoenix area and Tucson area high schools to come to the border or come to a certain location within the state of Arizona, go to a mile marker on I-8 or I-19, and then you will meet somebody and you'll get paid anywhere from $500 to $2,000 per passenger, per load, and then deposit them at some other place, notably usually close to a stash house in Phoenix. What this bill seeks to do is to provide a reasonable deterrent to those who would engage in chases to avoid detection. We have seen people from all over the country come in, and also people from across the border come in and drive these vehicles. The dangers in these communities, whether it's Sierra Vista, Naco, Douglas, Yuma, Nogales, all of which sit right on the border, from the chases that take place as people run, has got to end. And this notion that if you have an increased penalty or an enhancement to a penalty, you're not going to see deterrence doesn't seem to actually logically make sense. Everywhere that you actually enforce the law and you actually impose punishment, then you actually have general and specific deterrence. And even if you don't get general deterrence with this bill, I would suggest to you will get specific deterrence, and that will make these communities along the border safer. With that, Mr. Chairman, I will yield to the gentleman from California.
I just wanted to point out that the gentlelady seems to be surprised that people who break the law are fearful of law enforcement. Well, of course they are. They're supposed to be. They're breaking the law. They're being called to account for it. Lawbreakers should fear the law. But the point that this is not welcomed by law enforcement, I simply reminder that Chief Rodney Scott, the former chief of the Border Patrol, has been asking for this provision for years on behalf of his officers. So it's very much welcomed by the line officers whose lives are daily placed in jeopardy by these lawbreakers. I yield back to the gentleman.
Thank you. I'll yield back. Thank you, Mr. Chairman.
Chair recognizes Ms. Scanlon.
Thank you. I move to strike the last word.
The lady is recognized.
And I would yield to Ms. Escobar.
Thank you so much, Ms. Scanlon. One of our colleagues just mentioned that someone on this side of the aisle used one egregious example to inflict it across an entire group of people. That was what one of our Republican colleagues just said. I would say that is exactly what my Republican colleagues do over and over and over again when it comes to immigrants and migrants. How many subcommittee hearings, how many committee hearings have we had where my Republican colleagues want to try to paint every immigrant with a broad brush, making Americans believe they are all criminals, that they all should be feared? So I would say it's really an opportunity for my Republican colleagues to take a look at exactly what they're accusing this side of doing. Also, I think it is really important to state, I would like to see an end to human trafficking. I would like to see an end to the inhumanity that's happening at our nation's front door. I witness it every time I'm home. I have lived it as a border resident. But the best way to do that is to open up legal pathways, because what incentivizes illegal human trafficking is the closing off of legal pathways, which is exactly what's been happening for decades by the federal government. Lastly, I would say, I just have to wonder, at what point do our colleagues want to stop complaining about this and actually want to solve the issue? And you all can point, our Republican colleagues can point to H.R. 2 as their solution, but as I have said over and over again, I would encourage you all to read it. Fundamental to H.R. 2 is that Mexico will accept every single migrant this country decides to send them. That's never happened. It will never happen. So when you take that component out of H.R. 2, all of it falls apart. So I would welcome our Republican colleagues to join with us in a real solution. And right now, there's only one bipartisan comprehensive immigration reform bill that addresses the border and beyond. It's a bill called the Dignity Act of 2023. My Republican colleague, Maria Salazar, and I worked on it. It is a real solution, a real compromise. But y'all have a choice. Either you can keep complaining about this and using it as a political cudgel, or you can put pen to paper and get to work to solve this together, because I guarantee you, all of us on this side of the aisle want a solution. Some of us extended a hand of friendship and collaboration to the other side of the aisle to find that solution. I would welcome you to join me. But back to this amendment, all that this amendment asks for is that people be convicted of the crime that they are accused of before they are deemed deportable, and that's for legal permanent residents. Thank you, Ms. Scanlon. I yield back to you.
And I yield back.
Further discussion, Mr. Van Drew.
Just briefly, I think we have to put this in perspective. Illegal activity is illegal activity. No nation that has ever prevailed has open borders. A mere 4 years ago, we have the border under control. Now, a bipartisan answer, I do not believe, is to just allow the borders be open and process individuals even more rapidly, spend more money on processing. I think the answers are in H.R. 2, which is to finish the wall. And the wall does work. I've seen the wall. Where the wall exists, folks don't cross over. Where it does exist, where it doesn't exist, they do cross over. I think that's clear. And the return to Mexico policy did work, as the policies that we had 4 years ago, and immediately expediting back to the country of origin did work. And all the other policies they had. We need more Border Patrol. We need to button up the borders. We need to make sure that, the word isn't out that the borders are open. I mean, it was so telling, and I know I'm reviewing what now is almost ancient history, but quite frankly, when President Biden won, illegal immigrants that were ready to cross the border were wearing Joe Biden T-shirts. That's for a reason. He knew he wasn't going to enforce the law. This is elemental. It's not that complicated. There is a law that you can't cross into the United States of America, which most countries have similar laws, illegally. And so in the process of committing an illegal act, not only did you do that, but then when somebody is trying to apprehend you, you engage in a high-speed chase, which endangers the law enforcement individual. It's wrong. And they're even responsible for another crime at that point. You know what? And to the point that they fear Border Patrol, I'm telling you, there's a lot of people, millions upon millions of people in the United States of America who fear what's happening on our border, fear the fact that we know that people on the terror watch list are slipping in, fear the fact that the drug cartels control our borders, not the United States, not Mexico, but the drug cartels. Fear the drug cartels, fear the fentanyl, fear the illegal activity. It's illegal. It's not complicated. It's wrong. So I would say if we want to have a real answer, button up the borders, stop the illegal activity, and then you can discuss revising immigration law. But until that time, it's a moot point. We need to have the law obeyed. And when somebody goes out of their way by trying to escape, they commit a further infraction, and that adds to it, and it is wrong. It endangers the good men and women who work in the Border Patrol. And to Ms. Jayapal's point, yeah, I'm sure there are individual Border Patrol agents who aren't good people. There are individual members of Congress who aren't good people. There are individual doctors and dentists who aren't good people. My point is, in every profession there are. That doesn't mean that the majority of Americans who are law-abiding fear law enforcement. They don't. There's some bad eggs, but they don't. And this is the point. So let's do the right thing. I support this legislation, and I applaud the author of the legislation.
Would the gentleman yield?
I will yield.
To me, please.
Yes. Chairman, I will yield to you.
Thank you. The gentlelady from Texas accuses Republicans of painting with a broad brush, and then once again does what the Democrats always do. They paint legal immigrants who obey all of our laws, who do everything our country asks of them, who wait patiently in line, who come here to become Americans and raise their children as Americans because they love this country, and paints them with the same brush as illegal immigrants whose very first act on American soil is to break our laws, thumb their noses at our nation's sovereignty, and then demand services from American taxpayers. That is painting with a broad brush. It is insulting to the legal immigrants of our country who for 2.5 centuries have been the law-abiding, productive part of our society.
Would the gentleman yield?
Yield back to the gentleman from New Jersey.
Would the gentleman yield?
I will yield.
Thank you, Mr. Van Drew. I think I heard you say that you thought that we shouldn't reform our immigration laws until we secure the border. Is that accurate?
It's your time.
Yes, I'll yield back to myself. Absolutely.
Well,
we have to get. The situation is totally out of control.
Yeah, and this bill actually does reform. This bill actually does reform our immigration laws.
Paul, the gentleman is out of time, but one of your members can yield you more time if you wish. Is there any further discussion?
Did you want to speak?
Ms. McBath.
I move to strike the last word.
Gentlelady's recognized.
I'm so sorry I have missed this discussion, but absolutely, we do have major problems at the border, and until we come to some resolutions, some of these comments that are being made today are negligent, but I'd like to yield the balance of my time to my colleague, Pramila Jayapal.
Thank you so much, Ms. McBath. I just wanted to say that this bill actually does reform immigration law. So we haven't, in your words, haven't secured the border, but we're reforming immigration law. I also want to say that it sounded like my colleague was saying that somebody was guilty the minute they're accused of being guilty, but not convicted. And there are many people, I think, that would disagree with that on both sides of the aisle, that there is due process. All this amendment does, Ms. Escobar's amendment does, is say you need a conviction for deportability. That is important. That is a big change that the other side is making to say if somebody is just accused of something, that immediately makes them deportable. All we're saying is there are many problems with this bill, but at a minimum, let's stick to due process. Let's make sure that we require a conviction for deportability. The chairman conflated admissibility and deportability. For deportability, it is required for crimes of moral turpitude that you have a conviction. And that is what the majority is trying to change in this bill. I think it's unacceptable that we would somehow say due process doesn't apply anymore the minute somebody is accused of a crime, that would immediately lead to being deportable. That's just not acceptable. So that's the amendment. And I think we should be clear that it's a minimum requirement of due process to at least be convicted. And I hope that the majority would agree and vote for this amendment. I yield back to Ms. McBath.
I yield back the balance of my time.
Gentlelady yields back. Is there further discussion? Mr. Bishop. Oh, I'm sorry, Ms. Bartz. No, you were next, Ms. Bartz.
I'm going to strike the last word. I'll just be brief. But it's kind of interesting to me that we're debating here about, what due process needs to be for people who actually come into country illegally. So I have little reservations with all of the due processes entitled already people that who break the law, willingly breaking the law and coming through the border illegally, not going through the process of legal immigration. And I agree, that unfortunately, legal immigration has serious problems, but this large-scale illegal immigration cause now even more problems to come here legally into this country. And I think we do need to, protect our border, and we cannot deal with legal immigration, improving it until we actually do secure our border. But people actually, it's interesting enough, people actually now who come here with no bad records and bad intent, they try to be caught by Border Patrol because you get a lot of free benefits. We now have immigration to welfare. You actually get more benefits if you're here illegally than if you're here legally, and less responsibility to your judgment proof. So they actually try to be caught by Border Patrol because that's how they get the NTAs and everything else. So people, when they try to escape that, generally would be more likely to have some ill intent and some problem with them, because as I've seen that, unfortunately, now the Border Patrol and everyone else and the orders of this administration let everyone in, even people that don't claim asylum, because they come in large quantities and cartels are using these people as pawns for a lot of illegal activity, including distracting our Border Patrol from doing their duties. So it's a very serious situation, but I don't think we can even have a conversation what to do with legal immigration, which needs to be significantly improved, and discuss how we can better benefit our country and how we can bring the best and brightest people who want to really live by our laws and contribute to America. But we cannot do that conversation until we secure our country. And I think there are some policies in HR too that are very significant, that we have to deal with them, and we have to deal with Mexico and really with cartels to put pressure on them, but also Mexican government to collaborate on this issue with us. It's a very serious issue, and unfortunately we've been playing politics with people's lives, and we have to do something about it, and this is an issue. I hope that border security will also become an agenda, my Democrat colleagues, because it's a very serious situation, and I think that shouldn't be a partisan issue, and we have to resolve it because we have to save our republic and be strong. We have a lot of adversaries and bad people around the world that can take advantage of weaknesses of our border security, and we cannot neglect it. And I hope that we'll find some common sense and put pressure on this administration and my Democrat colleagues. I hope they will be willing, to be open-minded and not to be afraid to challenge their own party. We have much more independence on our side to challenge our own party when we disagree and when it's important for the American people. And I'd be happy to yield some time to my colleague from New Jersey.
I thank the gentlelady. Let's be clear. These are people who have already committed an illegal act. They are illegal. They should be deported regardless of whether they were in a high-speed chase or not. So we have to, again, button up our borders, stop this flow, and then figure out in an intelligent way what we want to do as far as immigration. But whether a high-speed chase or not, I don't understand what folks don't understand about this. They are committing an illegal activity. They are breaking United States law. I yield back to the chairman.
Will the gentlelady yield?
I yield to the chairman.
Just to allay the concerns of the gentlelady from Washington, I point out the provisions of this bill require an admission before the individual can be deported. I yield back to Ms. Spars.
Back.
Gentlelady yields back. Is there further discussion? Ms. Jackson-Lee.
From the very beginning, I hope to express all of our deep sympathy to the family of Agent Raul Gonzalez and acknowledge the Raul Gonzalez Officer Safety Act for the elements that are extremely important to all of us. As it is, it would establish criminal and immigration penalties for flight in a motor vehicle from a pursuing U.S. Border Patrol agent or any federal, state, or local law enforcement assisting in such pursuit. On its face, those are important issues that we should be concerned about. We grieve the loss of Agent Gonzalez and honor him and grieve the loss to his family. We honor him again and honor his service and dedication to the safety and security of our country. As individuals who are to affirm the adequacy of our law enforcement, we also need to ensure its fairness and adherence to the law. It goes without saying that I cannot support this bill if the mandatory minimum penalties remain, especially since they would be triggered without a finding of intent to inflict serious bodily injury or kill. And still, there are larger issues lurking in the definition of the offense, namely the elements that must be proven to establish a violation. Many people are concerned that in our effort to strike fairness and honor our law enforcement, they too believe in fairness. As the bill is currently written, it seems to omit a nexus between the flight and the pursuit, such as an attempt by law enforcement to stop the vehicle. Even if they somehow make it past the vague definition of the offense, prosecutors will be required to prove not that the Border Patrol agent was acting within their duties as an employee, but that the agent had the legal authority to engage in a pursuit, which is a considerably more involved question. I want to believe H.R. 5585 is a legitimate effort by my colleagues to protect not only our very valuable law enforcement officers at the border, but the safety of other human beings, migrants, citizens. But the true nature of this bill is revealed in the immigration provisions that will levy consequences as severe as inadmissibility and deportability without requiring a conviction. One thing we know in this country, that we believe in the fairness of the law. We believe in the honesty of the law. We believe in tribute to our law enforcement officers that they will want to have an honest system of law that responds to the loss that we've suffered when we lose a valiant officer like Agent Raul Gonzalez. With that in mind, let us work together to shore up the many faults apparent in this patchwork of ideas. And with that, I yield back.
Gentlelady yields back. Is there further discussion on the amendment? Seeing none, the question occurs on the amendment by the gentlelady from Texas. Those in favor say aye.
Aye.
Those opposed say no. The noes appear to have it.
Roll call vote, please.
Roll call is requested. Secretary will call the roll.
Mr. Jordan. Mr. Issa. Mr. Buck. Mr. Gates. Mr. Biggs. Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes no. Ms. Sparts. Ms. Sparts votes no. Mr. Fitzgerald. Mr. Bentz. Mr. Bentz votes no. Mr. Klein. Mr. Armstrong. Mr. Armstrong votes no. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Moore. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Mr. Moran. Mr. Moran votes no. Ms. Lee. Ms. Lee votes no. Mr. Hunt. Mr. Fry. Mr. Fry votes no. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson Lee.
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Swalwell votes aye. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. McBath votes aye. Ms. Dean. Ms. Dean votes aye. Ms. Escobar. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Ms. Ballant. Ms. Ballant votes aye. Mr. Biggs, you are not recorded. Mr. Biggs votes no. Mr. Issa, you are not recorded. Mr. Issa votes no. Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no. Ms. Escobar, you are not recorded. Ms. Escobar votes yes.
The vote's 11 in the affirmative and 13 in the negative. Oh, sorry. Clerk will announce the vote.
Mr. Chairman, there are 11 ayes and 13 noes.
Vote being 11 to 13, the amendment is not agreed to. Are there further amendments?
Mr. Chairman,
Chair recognizes the gentlelady from
I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 5585, offered by Ms. Jackson Lee of Texas. Page 1, beginning on line.
I reserve a point of order.
Be regarded as
Gentleman
read.
reserves a point of order. Without objection, the amendment will be considered read. The gentlelady is recognized for 5 minutes.
I thank you very much, Mr. Chairman. We all continue to offer our deepest sympathy to the family of Agent Raul Gonzalez and all of those who have fallen in the line of duty, either serving in the United States military or any number of law enforcement, federal, state, and local throughout the nation. We know that they love their country, love their states, and love their communities. And I say that again about Agent Raul Gonzalez, to his family. My amendment makes a technical change to mirror language that appears in federal criminal statutes that prohibit the commission of various offenses, including assault, murder, and manslaughter, perpetrated against officers and employees of the United States and foreign officials while engaged in the performance of official duties. As currently written, H.R. 5585 would require that the government prove beyond a reasonable doubt that the pursuing Border Patrol agent had the legal authority to engage in the underlying pursuit. In other words, the fact finder would have to determine whether the agent was abiding by laws and regulations in effect at the time of the pursuit. On the other hand, my amendment would simply require that the government prove that the Border Patrol agent was acting within their duties, meaning within the scope of the agent's employment, a much more just response. Second, my amendment would eliminate the minimum mandatory penalties in the bill while maintaining the maximum penalties. Like many of my colleagues, I've long worked to address mandatory minimum sentencing, particularly because of the devastating impact these sentencing schemes have inflicted on communities of color across the country and impoverished communities. Mandatory minimum sentences contributed to the mass incarceration of generations of Americans and are the primary reason the United States has the highest incarceration rate in the world, including people of color, but also impoverished communities that include people of many backgrounds. Mandatory minimums have been studied extensively and have been found to distort rational sentencing systems, discriminate against minorities, waste billions of taxpayer dollars, and quite often violate common sense while failing to reduce crime. Brain trusts like the Rand Commission have concluded that mandatory minimum sentences are less effective than discretionary sentencing and far more costly. Families Against Mandatory Minimums, FAM, the American Bar Association, Judicial Conference of the United States, and many other major organizations focusing on the criminal justice system oppose mandatory minimum. The Judicial Conference of the United States have reiterated to this body its opposition to mandatory minimum sentencing schemes more than a dozen times, noting that these types of penalties severely distort and damage federal sentencing, undermine the U.S. sentencing guidelines mandated by the Congress to promote fairness and proportionality in federal sentencing, and destroy equity and honesty in sentencing by encouraging coercive charging practices and cookie-like sentences. My amendment considers also the many criticisms of mandatory minimum penalties while allowing judges the discretion to impose informed sentences to satisfy the purposes and goals of federal sentencing. Lastly, my amendment would add an additional data point to the annual report, the immigration status of individuals charged with an offense under the new code section. In the end, the changes proposed in my amendment are narrowly tailored to address glaring deficiencies and do not change the overall mission of the bill. I ask my colleagues on both sides of the aisle to vote yes for a very constructive amendment that comports with being fair and just and also solving this problem. With that, I reserve.
Does the gentlelady yield? Gentlelady yields. Is there a discussion? The gentleman withdraws his point of order. Is there further discussion on the amendment? Chair will recognize myself for a moment. I just want to point out that serious crimes require serious consequences. This amendment would provide for little, if any, consequences. And this is the kind of law enforcement that we've come to expect from the left wing of the Democratic Party. We've seen this attitude unleash rampant law breaking in the cities they control. And we're now seeing it once again seep into the deliberations of this committee as well. I think the American people have had enough of this, and they will want us to reject it here as they will reject it at the polls. I'll yield back the balance of my time and ask if there's further discussion. Ms. Macbeth.
Thank you, Mr. Chairman. I move to strike the last word.
And ladies recognized.
I do hope that we can come to some resolutions today. We've been, spending a lot of time and effort over the years here, and we still haven't been able to solve this crisis. And I really hope that meaningful words are spoken here today and with commitment towards making sure that we find these resolutions. But with that, I will yield the balance of my time to my colleague from Houston, Sheila Jackson-Lee.
The gentlelady is much appreciated both for her leadership on so many issues and her yielding on this very important issue. Let me clarify to the gentleman his misinterpretation of my amendment or intent. The legislation stands, but we make the legislation certainly more effective because my amendment makes a technical change to mirror the language that appears in federal criminal statutes that prohibit the commission of various offenses, including assault, murder, and manslaughter perpetrated against officers and employees of the United States and foreign officials while engaged in the performance of official duties. And the RAND Corporation is no liberal bastion. And this is not left or right. It is only fair. Because my amendment would, in fact, equate to realizing that mandatory minimums are less effective than discretionary sentencing and far more costly. Organizations like FAM and the American Bar Association, Judicial Conference of the United States, that's judges, and many other major organizations focusing on criminal justice oppose mandatory minimums. That is what we're trying to do, give the judge the opportunity to render that strong judgment or not. The Judicial Conference that is made up of judges appointed by all presidential persons of all parties has reiterated to this body its opposition to mandatory minimum sentencing schemes more than a dozen times, noting that these types of penalties severely distort and damage federal sentencing, undermine the U.S. sentencing guidelines mandated by Congress to promote fairness and proportionality in federal sentencing, and destroy equity and honesty in sentencing by encouraging coercive charging practices. Now, we want to hold people accountable. I would hope all of us, Republicans and Democrats, but we would not want a distorted system. Mandatory minimums have been studied extensively and been found to distort rational sentencing systems, discriminate against minorities, waste billions of taxpayers' dollars, and quite often violate common sense while failing to reduce crime. And so all that this legislation indicates in its fairness is to ensure that the judges proceed in their duty of sentencing and be able to maintain maximum penalties as needed. And as well, to realize that the issue of providing penalty does not weaken when a judge uses all of the information that they would have. And this bill, as presently written, would require that the government prove beyond a reasonable doubt that the pursuing Border Patrol agent had the legal authority to engage in the underlying pursuit. In other words, the fact finder would have to determine whether the agent was abiding by laws and regulations in effect at the time of the pursuit. My amendment instead would simply require that the government prove that the Border Patrol agent was acting within their duties, meaning within the scope of the agent's employment. Could you not see the rationale and reason in that? That is being more fair.
Would the gentlelady yield?
I'll be happy to yield to the gentleman.
But leave aside that point, which I don't contest, but it also strikes out the 5-year minimum. I mean, I understand you talked about mandatory minimums a minute ago, but as far as administering a stiff penalty, it takes that away, right?
Well, regaining my time, what it does do is to give to the federal system where judges are appointed by presidents from both sides of the aisle, the opportunity to render a fair sentence, and I would have confidence that they would render a sentence that would be appropriate and above the 5-year if called for. And that is the point that is being made, that would occur, as well as simply require that the government prove the level of participation of Border Patrol agent rather than a more extreme level of proof. You'd be able to have one that was not. This protects the Border Patrol agents more than the present language that we have.
Gentlelady's time has expired. Is there further discussion?
Move to strike list. Yes.
Mr. Bishop.
Thank you. I'd like to debate the motion or the amendment. You know, it's interesting. I was in Homeland Security earlier today where the issue is, of course, Secretary Mayorkas's brazen and historically unprecedented defiance of the laws statutes Congress has passed to limit the executive's discretion in certain ways and require detention of certain illegal immigrants. And there, the comments have been, much as the minority's comments have been here. In every case, in every point under discussion, the proposition is offered that Democrats would like to work with Republicans to solve this problem, but the Republicans won't work to solve the problem. And yet, I continue to listen in vain for any policy proposal from Democrats other than, number one, to send more money to the border so that immigrants who are flooding the New York City, Chicago, Denver, all these cities, to the point that officials there are saying we can't handle them. So policy proposal one is to send more resources to the border so that people will be processed into the country faster and in ever greater volumes. And then number two, the other proposal that is offered persistently and has been for many years is to say, and we want to confer legal status of one form or another to legitimate what is now illegal immigration by the people that are coming. And I just don't understand. Here's what's happened in this administration. In a historically unprecedented way, Secretary Mayorkas, with the leave of the president, has defied any limitation on allowing people to enter the country. The result of the policy purposefully undertaken is exactly what we're seeing in all of these cities. It is a policy that is extra legal, that is to say it violates law, but it is nonetheless exactly the policy prescription that Democrats want to effectuate by changing the law. This is in every single respect a policy disaster that is owned by the Democratic Party and by the policy that the Democratic Party has persistently pursued for all of my adult life, certainly since the mid-'80s, when President Reagan first acceded to the idea of granting amnesty in return for the elusive promise that we would secure the border. It's never happened to secure the border, never been done. The proposal that is currently before us is about administering a stiffer penalty for a specific, very precise micro problem, which is because high-speed chases are occasioned by this gross disorder on the border, and people are being killed in the process. So it is trying to administer something of a stiff penalty to try to deter just that one little form of misconduct. And what is the response? Every response from the Democrats is we don't want to have any stiff penalties because stiff penalties are bad. You're over-policing communities. Communities will be frightened because one time in history a Border Patrol agent went rogue and did something awful to somebody. And so people might legitimately fear. Look, this persistent pursuit of disorder, a policy of cultural and civic disorder, undermining law enforcement mechanisms across the country that Democrats insist on persistently maintaining and pursuing, is creating victims. It is killing people. It is killing the country. Your own Democrat-run cities are experiencing crises because of it. And still, your only answer is to say, we need to make what we've done outside the bounds of law, within the bounds of law. How in the world will that solve the problem that you have created? That's the question that I think is always begged, never answered. I hope someone will take the opportunity to tell me where I'm wrong and cite an example of where that you're departing from that. Either one of the two things always. Send more money so we can process people in faster and confer legal status so that the illegality goes away. How does that solve the problem that New York has with migrants on the sidewalk outside the hotels that are being rented by the federal government?
The gentleman's time has expired. Mr. Nadler.
Move to strike the last word.
Gentleman's recognized.
Mr. Chairman, I find Mr. Bishop's words very enlightening. He points out that since President Reagan's time, we have not secured the border. I thought it was only since President Biden's time that we haven't secured the border. Mr. Bishop admits that the first President Bush, second President Bush, President Trump, not to mention Clinton and Obama, haven't secured the border. He said so. It's true. But don't blame the President Biden alone, as that resolution we passed yesterday does, for something that no president has been able to do since 1986. Second, this president, Biden, has proposed doing something about it. Mr. Bishop just derides it as throwing money at it. Well, if you passed the president's requests for funding for more Border Patrol agents, so you could stop more people from coming across, for more asylum judges, the Republicans always decry the catch and release. We catch people and we release them into the country. Why? Because they're entitled to asylum hearings, and the asylum system is so backed up that it takes years in which before they can be adjudicated. If President Biden's budget requests are granted, it would take weeks, and the people who are not entitled to asylum would be evicted from the country within weeks instead of years. The people who are entitled to asylum would get the asylum. So I'm grateful to Mr. Mr. Bishop, for clarifying that the crisis at the border has been a crisis for every presidential administration since President Reagan. And it isn't just President Biden.
Would the gentleman yield?
No, I won't yield. And it's also the case that if we granted, if Congress voted, if the Republicans were willing to vote the appropriations that the president has requested, you wouldn't have the catch and release. Well, you'd have catch and release, but only for a few weeks, not a few years. So it's exactly the opposite from what the gentleman paints, and I'll yield.
I thank the gentleman. And I don't differ with what you've said. Persistently, across 30 or 40 years, Republicans have in good faith played Lucy and Linus and Charlie Brown with the football. Democrats have always argued, let's grant some more amnesty, and in exchange, we promise that the border, we're going to pass border security provisions, and then the border security is going to be provided for. It never occurs, and that is the point that I've made is Democrats have been willing, as Secretary Mayorkas has done, to say even if you take I forget the name of the law passed in the statute passed in 1996 that the Supreme Court spoke to last June in United States versus Texas. Secretary Mayorkas has completely disobeyed Congress's mandate to detain certain illegal migrants. He's just ignored it. So he's done it, as I say, extra legally. It's not, look, there are Republicans who are also at fault here. There's no doubt about it. But that is what has not been ever done. And so, and now, in the Biden administration, it is a difference of kind because it is a difference of scale.
Would the gentleman yield? Mr. Bishop, would the gentleman?
It's the gentleman's time. I'm sure he'll take back from you.
Thank you, Mr. Nadler. I just wanted to say that I want to draw people's attention back to 2013. In 2013, there was a bipartisan immigration bill passed. It had a lot of bipartisan votes, 68, as a matter of fact, which is hard to imagine today. It had legalization. It had many of the modernization that the immigration laws needed. And in exchange, it had a number of border security provisions, money, but also provisions to secure the border. Passed the Senate with 68 bipartisan votes, and you know what happened? It came to the House, and John Boehner was the Speaker. And John Boehner did not bring the bill to the floor because Republicans said, we don't want to fix this problem. Don't bring the bill to the floor. And so John Boehner didn't bring the bill to the floor. And so the reality is we have sat here with a broken immigration system because Republicans like having this out there so that you can continue to blame immigrants for everything that's wrong with the country. And that I find really outrageous because you can't say that when it takes 20 years, 25 years for somebody to be able to bring their adult child to this country, that's an immigration system that works.
Yeah.
I mean, I came here at 16 years old. I am one of those people that the chairman refers to as a legal immigrant. I am not outraged by people who are at the border.
The gentleman's time has expired. Mr. Moore. Mr. Armstrong.
Move to strike the last word.
Gentleman's recognized.
Thank you. Well, allocating more money to bad policies just accelerates the outcome of those terrible policies. But after that, I would yield to my friend from New Jersey, Mr. Van Drew.
I thank the gentleman from North Dakota. Let me be clear again. 4 years ago and now. 4 years ago, we were using Title 42. 4 years ago, we had the stay in Mexico policy. 4 years ago, we were letting Border Patrol do their job, not to process more and more illegal activity, but to make sure they were protecting the border. 4 years ago, we were immediately expediting wherever we could back to the country of origin. 4 years ago, we were instituting more technology at the border to make sure to keep it whole. 4 years ago, we had the wall being built where it does exist. They don't cross. 4 years ago was vastly different than where we are now. So I associate myself with the remarks from the gentleman of North Carolina, but I will say that 4 years ago, under President Trump, we had major improvement. And, you know, my friends on the other side of the aisle, we have American citizens, urban minorities, in our cities and in our rural areas, people that are black and brown that are being underserved because of what is happening to the urban areas in which they live. We had to, in New York City, they've reduced the amount of money going for public safety because they have to spend it on illegal activity, illegal aliens. These are illegal activities. That's the point here. We're arguing whether someone who is involved in a high-speed chase trying to get away because they've committed illegal activity should be deported. They should be deported whether they were in a high-speed chase or whether they were not in a high-speed chase. They shouldn't be in the United States of America. We can't have open borders allowing everybody from every place in the world to come to this country. Certainly, I believe in immigration legally. I love it. And as was said here before, it is an insult. It is an insult to the millions of legal immigrants who waited in line, who pledged their support to the United States of America, who believe in our flag, who believe in our Constitution, who believe in our Declaration of Independence, and learned about it, and want to become part of America. That's the kind of immigration I believe in. In order to accomplish that goal, we must close down and button up our borders to illegal activity. And I yield back to my friend from North Dakota.
Gentlemen, yield.
Just a second. And I would also point out that under current border policy, if you turn yourself into Border Patrol, you're getting an amnesty date 5, 6, 7 years away. You're getting catch and release into the interior of the country. It's not like a ton of people who are showing up are being put on a train and sent back home or a plane being sent back home. So one would have to wonder what kind of activity is required in order for you to try and evade law enforcement. What kind of activity? Is it fentanyl? Is it opioids? Is it human trafficking? Is it something more nefarious than that? Because if you are going and applying for amnesty, you're not running. You're turning yourself in. You're turning yourself into the first person wearing a federal law enforcement uniform, because you know you're going to get released and you know you're not going to have a court date for years. So the people running from law enforcement aren't asking for amnesty. They're doing something else. And with that, I yield to my friend from North Carolina.
I thank the gentleman, and to my friend from Washington, the state of Washington, I say that the proposal back in 2013 to which she refers is another example of exactly the same thing, in which Republicans are deluded into buying the idea that in the face of unrelenting illegal migration that is allowed particularly and especially and overwhelmingly by Democrat administrations, that the way to solve the ensuing problems that are inevitably occurring is to agree to grant amnesty and give more money so that more people can be processed into the country. How any rational mind conceives that doing those things will solve the problems that are born of an unrelenting stream of migrants who are not, for whom the country is not prepared for, I do not understand. And I don't think anyone's ever addressed it. As I say, I've got to confess, they have achieved their objective both by extra-legal means and when they're talking about changing law, it's always in the same direction. What I would like them to do is bear the responsibility for the results that they have obtained.
The gentleman's time has expired. Mr. Ivey.
Thank you, Mr. Chairman. We got a little far-flung from the actual bill that's pending, I think, but since we're bringing it from Homeland Security, I did want to respond to some of what's been said, because it's just not true that the Democrats have not proposed legislation that did anything beyond additional resources, although I think everybody in the world thinks additional resources would be helpful. As a matter of fact, at the hearings we had when the Border Patrol agents came up and testified, every last one of them said additional resources would be helpful. So I'm not really sure why that's a criticism piece, but just to list off a couple of things off the top of my head that I can recall us also proposing: the additional judges so we could move through the process more quickly. As the ranking member mentioned, we've got 6-year backlogs. Let's get additional judges so we can resolve these cases more quickly without violating the pending law with respect to asylum. We know the law's there. Why don't we just move these cases more quickly? But we also propose things too, like additional technology for scanning the trucks, which 92% of the fentanyl comes through, not in between the ports, but through the ports. And we went down to the border. That's exactly what Border Patrol told us. They've got a couple of them covering a couple of the ports, but not the others. So guess what? The cartels are now diverting their trucks and cars to the other ports. So, I mean, there's a variety of things like that. Drones was another big one that troubled me. The Border Patrol said, they've got us outnumbered 17-1 on drones. Can we get additional resources for drones so we can counteract it? Matter of fact, one of them said, they're hitting a point where they're not even going to bother with the trucks and the backpack stuff anymore because they can take it over by using the drones. And they're buying up land along the wall that you guys swear is so fantastic so that they can do it that way. And the last piece on that, when I was down there looking at this wall, the streets run right in between the wall. Anybody could drive a car right through it. So I'm like, well, what's the big deal with the wall? There's no tower, there's nothing. You could just get in your car and drive through. And the proposal is billions of additional dollars to build, I think it's 900 additional miles to get it done. And Trump didn't even get done what he was proposing to get done. So, thank goodness the Senate is having bipartisan discussions to try and work something out. You might not like what they're proposing. I might not like what they're proposing, but at least they're working on it. And when you sent H.R. 2 over there, they had told you before you sent it that it was going to be DOA. So when you say it's sitting on Schumer's desk, no, it is not on his. It's in the trash can. And guess what? It's in the Republicans' trash can too. That's why they're negotiating a new bill. They told you don't send it. It's got all these poison pills and stuff. It's off top. Why don't we send a real bill that can work? You didn't. So they're starting from scratch. And now we want to try and help them. The White House is there, Senate Republicans are there, Senate Democrats are there, House Democrats are there. Everybody's there working on, and Mayorkas is there too, by the way. Everybody's there but the House Republicans trying to get a bill done. So anyway, on this last point about all these violations of the courts, I just want to read the quote from United States v. Texas, which my friend referenced a few minutes ago. This is from Justice Kavanaugh, who wrote the majority opinion. By the way, it was an 8-1 opinion, so clear-cut winner in throwing out the state of Texas's complaints. But he wrote this: the executive branch does not possess the resources necessary to arrest or remove all of the non-citizens covered by current federal immigration law. That reality is not an anomaly, it is a constant. For the last 27 years since these laws were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests. So, back to the resources. Justice Kavanaugh, Trump's #1 draft pick, when he started building the Trump Supreme Court, he's telling you this. He's telling you they need more resources.
No,
just visibly. They don't have enough resources to do it all, so they have to make choices. If you don't like the choices they're making, that's one thing. But if he's got to make those choices based on the lack of the resources, which is expressly what he means when he says they cannot arrest or remove all of the non-citizens. I mean, what else does that mean? So, look, on the underlying bill, I'm going to vote against it just because it's already covered by the law. If you're,
Gentleman's time has expired.
Well, I thank the chairman. I yield back.
Mr. Roy.
Thank the gentleman from California. This underlying bill shouldn't be necessary. That's the simple truth. The underlying bill should not be necessary because the federal government's responsibility is to maintain, as statute dictates, as the Constitution suggests, explicitly and implicitly, as common sense would dictate in our federal system of government, the federal government has an obligation to maintain operational control of the border. It does not, in any meaningful way, does the federal government maintain operational control of the border. Texas has spent $12.5 billion trying to deal with what the federal government refuses to do. So go back to the underlying bill. The underlying bill is designed to ensure that when you have these high-speed chases, that there's penalties that attaches to that. But it shouldn't be necessary. Because if we actually had operational control of the border, which as the most powerful country in the history of mankind, we certainly have the capability to do. We certainly have the capability to do while maintaining the ability to provide actual refuge to actual asylum seekers, not the current process which the Secretary of Homeland Security acknowledged just last week. He's releasing 85+%, probably more like 90+% of all of the apprehensions. And when my colleagues on the other side of the aisle just dismiss this as saying, well, this has been a problem since the mid-'80s. Well, first of all, as my colleague from North Carolina pointed out, the order of magnitude is quite different. But even if you go back to the early 2000s when there was a fairly sizable spike at the end of the Clinton administration with the numbers, virtually all of those individuals, if you look at the data and anybody who experienced it living in Texas, those were Mexican nationals, almost entirely, looking to come to the United States for work. Now, there are things that flow from that, Plyler v. Doe, education, birthright citizenship, anchor babies, all the things that flow from that problem. But now, as everybody knows, it is vast majority what the Border Patrol refers to as other than Mexican, people from all over the world. And so you've got this rush at the border that is perpetuated and caused by the policies of this administration to release individuals. And as the ranking member of the committee referred to the right or expectation of getting a hearing, you're supposed to provide or be able to make a determination of credible fear of actual persecution for your religious or political beliefs. Anybody talking to any of the people coming across the Rio Grande into Texas, these are individuals who will say almost universally, I want a job. I want a better way of life. Those are the ones you talk to. Those are the ones that go seek Border Patrol, not the gotaways, not the $50,000 a month plus gotaways, but those seeking Border Patrol. Now, I, again, have stipulated in this committee hearing and countless times on the floor, I do not begrudge any of the individuals seeking a better way of life. But that is not what our law says. It's just simply not. So what did we do in sending H.R. 2 to the Senate? We tried to make clear and tighten the existing laws. Any administration could stop the flow today under current law, as they should, as the Trump administration did, using Remain in Mexico, negotiating with the Mexican government, and application of Title 42 during the COVID. But you can certainly tighten the, right now, enforcement under current law. H.R. 2 is designed to ensure that we actually get the job done. A colleague said it's filled with poison pills. What are those poison pills? That they would work? The poison pills are that this would actually get the job done?
Would the gentleman yield?
I don't have enough time to yield to you, but 20 seconds. It would work. That's the thing. It would work. You know, people don't like E-Verify. Okay, let's have that debate. We had a debate here. If you don't like something, but to make a blanket statement that H.R. 2 is somehow littered with poison pills and therefore unacceptable to the Senate on dead on arrival, that's because Senate Democrats have no interest in securing the border of the United States, and neither do my Democrat colleagues in the House. And Texas is bearing the brunt of it as a result.
The gentleman's time has expired. Is there further discussion on the amendment? Seeing none, the question occurs on the amendment offered by the gentlelady from Texas, Ms. Jackson Lee. Those in favor of the amendment say aye. Those opposed say no.
No.
The noes have it. And the amendment is not, roll call has been requested. Secretary will call the roll.
Mr. Jordan. Mr. Issa. Mr. Buck. Mr. Gates. Mr. Biggs. Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey. Mr. Roy.
No.
Mr. Roy votes no. Mr. Bishop. Mr. Bishop votes no. Ms. Spartz. Mr. Fitzgerald. Mr. Bentz. Mr. Bentz votes no. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Armstrong votes no. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Mr. Moran. Mr. Moran votes no. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson Lee. Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Mr. Neguse. Ms. McBath. Ms. McBath votes aye. Ms. Dean. Ms. Dean votes aye. Ms. Escobar. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy.
Aye.
Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Fry, you're not recorded. Mr. Fry votes no.
Secretary report? No. How is Ms. Escobar recorded?
Ms. Escobar, you are not recorded. Ms. Escobar votes yes.
Secretary report.
Mr. Chairman, there are 9 ayes and 13 noes.
The vote being 9 to 13, the amendment is not agreed to. There are no further amendments. The question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor of the ANS say aye. Aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no.
No.
The noes appear to have it. Oh, pardon me, the ayes, sorry. Ayes appear to have it, and a roll call has been requested. Should have let it go. Secretary, call the roll.
Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes aye. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Biggs votes yes. Mr. Fry, you're not recorded. Mr. Fry votes yes. Ms. Jayapal votes no.
We'll wrap it up. Sorry. I blame Bishop. I was a little equivocal there. No. Just tell him, shut up. That's what you just said.
Clerk will report.
Mr. Chairman, there are 14 ayes and 10 noes.
Vote being 14 in the affirmative and 10 in the negative, the bill is reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff's authorized to make technical and conforming changes. It's not an adjournment. It's not an adjournment. We are not adjourned. Pursuant to notice, I call up H.R. 6976, the Protect Our Communities from DUIs Act for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 6976 to amend the Immigration and Nationality Act to provide that aliens who have been
Without
convicted.
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Alabama, Mr. Moore, for an opening statement.
Thank you, Mr. Chairman. Every 45 minutes, that is how often someone in the United States dies in a crash involving an alcohol-impaired driver. In 2021 alone, there were 13,384 impaired driving fatalities and 400,000 injuries. Those crashes don't discriminate. The victim could be me, it could be you, it could be one of our family members. This issue hits close to home for me. There was a newlywed couple from my hometown of Enterprise, Alabama, named Angel and Jeremy C. I knew this couple personally. Angel and Jeremy were riding a motorcycle together when out of nowhere an illegal immigrant under the influence of alcohol collided into the newlyweds with his pickup. Their lives were cut dramatically short. However, tragedies like this are not uncommon across our country. Consider another case from Missouri where just 2 months ago, an illegal alien from Honduras was sentenced for driving drunk at 100 miles per hour and killing a man. Now, if you listen to my Democrat colleagues, you may think drunk driving is no big deal. In fact, my Democrat colleagues voted down the 3 Republican amendments that would have made certain aliens ineligible for green cards if they had 1 or 2 or even 10 or more DUI convictions. But that would come to no surprise. In 2020, then candidate Joe Biden said that illegal aliens with DUI convictions should be allowed to stay in the United States. Candidate Biden even called for ICE officers to be fired if they arrested illegal aliens without felony convictions. Today, I fear that instead of hearing the agreement from Democrats, we will hear far-fetched hypotheticals and accusations that this bill is cruel or too broad. But instead of engaging in hypotheticals, let's again revisit the facts. Drunk drivers are involved in 31% of all crash deaths in America. Our average drunk driver has killed nearly, on average, drunk driving has killed nearly 11,000 people in the United States every year from 2012 through 2021. Yet immigration laws do not make aliens inadmissible or removable if they drive drunk and recklessly break our laws. H.R. 6976 changes that and creates safer streets and safer communities for all of us. I urge my colleagues to support the Protect Our Communities from DUIs Act. With that, Mr. Chairman, I'll yield back.
Gentleman yields back. Chair recognizes the ranking member, Mr. Nadler, for an opening
Thank
statement.
you, Mr. Chairman. Mr. Chairman, this bill is yet another attempt by Republicans to score cheap political points while doing nothing to actually fix our immigration system. We can all agree that driving under the influence or a DUI is a serious issue. No one here wants to see individuals who are true threats to public safety eligible for immigration benefits. And our current immigration laws are already equipped to prevent that, especially with regard to DUI offenses. Under the Immigration and Nationality Act, a citizen who is convicted of or who admits to committing a crime involving moral turpitude, or a CIMT, is generally inadmissible. Likewise, a non-citizen who is convicted of CIMT where a sentence of 1 year or longer may be imposed is deportable. Serious DUI offenses are already CIMTs under current law. For example, the following DUI offenses are all CIMTs. A DUI where the maximum possible penalty is a year or more, and where there is serious bodily harm. Hit and runs. An aggravated DUI, and a DUI involving driving with knowledge of an invalid, suspended, or revoked license. But this bill goes way beyond that and seeks to expand the ability to remove and deny people entry in a way that I cannot support. It is important to understand that DUI offenses vary all over the country. Some jurisdictions do not even require the individual to be physically driving the vehicle for DUI offense to be committed. For example, in Virginia, an individual who is found asleep in his car with the keys in the ignition in a backwards position to activate the vehicle's auxiliary power was convicted of a DUI, even though his car was parked in his own driveway. Under current law, such an individual would not ultimately be subject to removal based on this conviction. But if this bill were to become law, conviction would cause even a long-standing lawful permanent resident or green card holder to be deported. Is this really what the majority is trying to legislate here? Do we really want to deport people who are here legally, who have deep and long-standing ties to this country, for making a mistake that did not endanger or harm anyone, as was the case in this Virginia DUI conviction? America's a nation of second chances. Let's not forget the words of former President Trump, who so many of my colleagues have endorsed in this year's primary. Quote, America's a nation that believes in the power of redemption. America's a nation that believes in second chances, close quote. I have no qualms about deporting those who commit serious DUI offenses, but this bill as written is too broad and overreaches in a dangerous way. Categorically deporting individuals who are convicted for any DUI offense without a closer look at the underlying facts will result in serious unintended consequences. I hope the majority is willing to work with us to improve this bill to ensure that it is appropriately targeted at behavior that puts our communities at risk. I yield back the balance of my time.
The gentleman yields back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from Alabama for the purpose of offering an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 6976, offered by Mr. Moore of Alabama.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair recognizes the gentleman from Alabama to explain the amendment.
Mr. Chairman, this amendment just makes small technical changes on page 2. It does not change the substance of the bill.
Gentleman yields back. Is there any discussion? Ms. Jayapal.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 6976, offered by Ms. Jayapal of Washington. Page 1, line 11, strike any alien and insert the following.
Without objection, the amendment will be considered read. The gentleman from Arizona reserves a point of order. And the gentlelady from Washington is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chairman. My amendment is straightforward and would help avoid the unintended consequences posed by the breadth of this bill. It would allow judges the discretion to consider mitigating factors before summarily ordering a lawful resident to be deported. I take DUIs extremely seriously. As my colleague across the aisle said, according to the National Highway Traffic Safety Administration, approximately 37 people die in drunk driving accidents per day in the United States. We can and should do more to prevent driving under the influence. But scapegoating immigrants over this serious problem is not a solution. As the ranking member discussed in his statement, many DUIs are already considered crimes involving moral turpitude, or CIMTs, and are already grounds for removal or inadmissibility. Serious public safety threats are already deportable offenses under current law. Unfortunately, that's not what this bill does. This bill would make anyone convicted of a single misdemeanor or felony DUI subject to deportation. I'm pleased that the majority is at least requiring a conviction, something we tried to have on an earlier bill, before making someone deportable, and not repeating the mistakes that it made in those earlier bills that we marked up today by mandating that folks be deported without having been convicted of a crime. But I am deeply concerned that they have not considered carefully the impact of DUI statutes across the country. You see, states have all sorts of different interpretations over what constitutes a DUI. The ranking member spoke about how the Commonwealth of Virginia interprets and prosecutes its DUI statute. In Arizona, the DUI statute allows people to be charged with a DUI if they are intoxicated and have, quote, physical control of their vehicle. The Ninth Circuit, in reviewing an appeal of a removal case for a non-citizen charged under this law, found that the physical control language meant that under this statute, and I quote, one may be convicted under it for sitting in one's own car in one's own driveway with the key in the ignition and a bottle of beer in one hand. While the non-citizen in this case had been ordered deported on the basis that his conviction under this statute constituted a CIMT, the Ninth Circuit overturned that ruling because the activities covered by the statute could not all reasonably be seen as crimes involving moral turpitude. As the court put it, and I quote, drunken driving is despicable. Having physical control of the car while drinking is not. If this bill had been enacted when this case had been decided, this case would never have made it to the Ninth Circuit because no judge would have the discretion to rule whether the crime merited deportation. This bill would prevent judges from being able to decide if the punishment fits the crime. This case and the case the ranking member discussed are just two examples of overbroad DUI statutes. These cases only made it to court because prosecutors chose to bring these charges. So it'd be implausible to argue that prosecutors would not waste their state's time by bringing minor DUI cases. Under these statutes, individuals are charged with DUIs for merely sleeping in their car. These people have potentially made the conscious choice to not drive impaired, and yet they end up punished. And to be clear, we're talking about green card holders, the immigrants that my Republican colleagues always claim to like, the ones that did it the right way. We're putting their fates on the line. And so, if the majority insists on pursuing this bill, I want to ensure that we allow immigration judges the discretion to decide if a DUI conviction from the large constellation of state laws actually merits deportation. My amendment would allow judges to consider mitigating factors, such as if anyone was harmed, if the person sought treatment for substance abuse after their DUI conviction, and the length of time since they were convicted of the DUI. This discretionary authority merely gives judges the option of choosing to look beyond just were they convicted or not. It does not require them to let anyone off the hook. It doesn't give them a get-out-of-jail card free. It would simply be a backstop so that if a green card holder was convicted of a DUI because they decided to sleep in their car rather than drive home drunk, an immigration judge could choose not to deport them. Everyone deserves a second chance, but this amendment actually doesn't even require that. It just allows judges the discretion to consider offering grace to someone who might deserve it. I hope I can count on my colleagues to support this simple, straightforward amendment, and I yield back.
Gentlelady yields back. Is there any discussion on the amendment? Mr. Biggs.
Thank you, Mr. Chairman. I rise in opposition to the gentlelady's amendment. You know, oddly enough, I tried a bunch of DUI cases in Arizona. I was a prosecutor, and then I defended. And probably did 75 jury trials, at least, and I don't know how many bench trials on DUI cases. APC in Arizona, actual physical control, I love that the Ninth Circuit picked out the what we would call the outlier. How about one of these cases? The accident's over. No one saw this individual driving. He's behind the wheel, drunk, very clearly intoxicated, well above the limit. Keys turned off, the car's inoperable. But that's one of the things APC was designed to cover, because we couldn't have made that case as a driving under the influence. We could under APC. How about this one? In the middle of the intersection, 1:30 in the morning, passed out behind the wheel, car's in idle. They're not considered to be driving under Arizona law. APC, that was actual physical control. So all that goes to say is while you want the discretion to be in the immigration judge, I want it to be in the trier of fact who actually took care of the case for which the individual is charged driving, or in Arizona law, an actual physical control. In Arizona, we have a robust canon of case law helping us understand what actual physical control is. There's a reason that we have it in Arizona, and it's consistent with what NHTSA, and I understand that some of you cited NHTSA previously, it's consistent with what NHTSA would say is a good practice, best practice. I think that the fact that somebody is convicted in Arizona for DUI, even if it's an APC case, should warrant removal from the United States of America. And I'll tell you why. The same NHTSA that you alluded to has done numerous studies indicating that the first time someone gets a DUI arrest is not the first time that that individual has been driving under the influence of alcohol and been a hazard on the streets. I think of Brandon Mendoza driving home after a shift in the Mesa Police Department. hit and killed by a drunk driver who had been driving the wrong way on a Phoenix freeway for miles. I think of several other people I've known who were killed by drunk drivers who were in the country illegally. I would suggest that the best person to make the determination on the type of DUI claim would be the judge who's actually sitting in either in the plea proceeding or in the trial. The immigration judge then would be able to, and under this law, do what's necessary, and that'd be to remove this individual, this hazardous, dangerous individual from the United States of America. I support the gentleman's underlying bill, and I oppose this amendment. I yield back.
Gentleman yields back, sir. Further discussion, Mr. Ivey.
Thank you, Mr. Chairman. This isn't a hypothetical to me. I had lots of these come across my desk when I was the state's attorney in Prince George's County, which is the eastern border of Washington, D.C. here. And we've had a very large immigrant population for more than 2 decades there, many from Central America and the like. Couple of quick points. One is there's a conflation of drunk driving and vehicular manslaughter or homicide in the way that you all are discussing the underlying provision. And by that I mean DUIs, which are serious offenses, but you're always talking about the number of deaths caused by drunk drivers, which is vehicular manslaughter or homicide, depending on your state. Now, there's a lot of those. We prosecute them. I don't think there's any doubt that if somebody gets prosecuted for a vehicular manslaughter, that's a deportable offense for sure. First-time DUI, though, that might not be quite the case. In fact, I know I've been at the Department of Justice. We had people there who had DUIs. I'm here in Congress now. There are people here who've had DUIs. I've been worked with professors at schools. There have been folks there that have had DUIs as well. So having that DUI, especially the first one, doesn't mean you're a vehicular manslaughter person. So if we could take a look at the cases that this bill actually covers, which is like everything, anytime somebody has a DUI, and consider a couple of these scenarios, like some that I had come across the desk. Person's illegal, been in the country for, 20 years, something along those lines. Been a pillar of the community, has employers that are willing to come in and talk about the great job they've done, and please don't have them deported. Neighbors, churches, the like, all come in support of letting them stay while they're sometimes they're waiting to try and get their status, corrected or whatever. But, these are not evil people per se. And the other point I wanted to make real quick too, and this is the difference between the local judges or the judges who are trying these cases and the immigration judges, that I found was almost always the case. For a DUI, which is frequently a misdemeanor in many jurisdictions, at least the first one, the last thing those judges are thinking about is whether it's a deportable offense. In fact, many of them presume that it's not because it's a misdemeanor and under those criminal statutes, a minor offense by definition. So, look, I'm not saying that anybody that gets a DUI, whether it's the first one or not, shouldn't be deported. It shouldn't be treated seriously. I'm not saying that at all. Some of your scenarios, DUI is driving 100 miles an hour wrong way down the highway. That's one difference that's very different from somebody's, woman who weighs 100 pounds, had one glass of wine, and she blows positive. So I just think it's reasonable to let a judge take a look at the facts and make a determination based on that. Because the facts that you're talking about over there, I think everybody would agree. Go ahead and deport them, sure. Somebody gets killed or something like, absolutely. But everybody? I mean, and it's, to say that every time somebody has one, that means they're automatically, they're just a recidivist waiting to happen, I think is demonstrably false. I just think that is not true. And in fact, most systems are structured around not that. That's why they have escalating sanctions as you have additional offenses. Instead of starting with the highest possible offense. And for a DUI, with nothing else there, a misdemeanor DUI, deportation is about as serious as a sanction as you can get. There really isn't anything that's going to be more severe for most of these people, especially folks who haven't lived in whatever that country was for 10 or 20 years, or they grew up here, or just whatever it is. Let a judge consider it and consider the facts. They're worried about the communities that they live in, just like you're worried about the communities we're elected from. Let's give them a chance to make the decision that they think is best on the circumstances in that case that they're presented with for that individual and for that community. And with that, I yield back.
Gentleman yields back. Is there further discussion? Seeing no further discussion, the question is the adoption of the amendment by the gentlelady from Washington. Those in favor say aye. Aye. Those opposed say no. No. The noes appear to have it.
Roll call.
Roll call is requested. Secretary will call the roll.
Mr. Jordan? Mr. Issa? Mr. Issa votes no. Mr. Buck? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? No. Mr. Nels votes no. Mr. Moore? No. Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Mr. Moran? No. Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Fry, you're not recorded. Mr. Fry votes no. Mr. Kiley, you're not recorded. Mr. Kiley votes no. Mr. Gates, you're not recorded. Mr. Gates votes no.
All members voted. Secretary will report.
Mr. Chairman, there are 8 ayes and 14 noes.
The vote being 8 in the 8 in the affirmative and 14 in the negative, the amendment is not adopted. Are there any further amendments? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on the reporting of the bill. Those in favor say aye. Aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. Those in favor of adopting the bill say aye. Aye. Those opposed say no.
No.
The ayes appear to have it.
Roll call.
Roll call is requested.
No, never mind.
What did I say? Roll call is requested. Secretary, call the roll.
Mr. Jordan? Mr. Issa? Mr. Buck? Mr. Gates? Mr. Gates votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes aye. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes aye. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes aye. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Fry, you're not recorded. Mr. Fry votes yes. Mr. Issa votes yes. Mr. Klein, you're not recorded. Mr. Klein votes yes. Mr. Neguse, you're not recorded. Mr. Neguse votes no.
Am I recorded?
Ms. Jackson Lee, you're not recorded.
No.
Ms. Jackson Lee votes no.
Two more, I think.
Secretary, report.
Mr. Chairman, there are 13 ayes and 10 noes.
The vote being 13 the affirmative and 10 the negative, the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. And that's also not an adjournment. Pursuant to notice, I call up H.R. 6678, the Consequences for Social Security Fraud Act, for purposes of markup, and move the committee report it favorably to the House. The clerk will report the bill.
H.R. 6678, to amend the Immigration and Nationality Act to provide that aliens who have been convicted of or who have committed Social Security fraud are inadmissible and deportable.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes himself for 5 minutes for an opening statement. H.R. 6678 makes aliens inadmissible to removable from the United States for committing Social Security fraud and identification document fraud. The numbers are staggering. In 2017, that's before the Democrats opened our borders and introduced the largest illegal mass migration in recorded history, there were 1.2 million cases in which illegal aliens had used Social Security numbers that either belonged to somebody else or were simply fabricated. A 2020 GAO report on employment-related identity fraud identified more than 2.9 million Social Security numbers with risk characteristics associated with Social Security number misuse. Last year, an investigative report published by Real Clear Investigations said this: reports dating back over a decade show that hundreds of thousands of Americans are unknowingly sharing, it's in quotes, sharing their Social Security numbers with illegal immigrants. Such victims may face tax bills for income they didn't earn or depleted benefits. Worse, some may experience the burden of bad credit histories and criminal records inaccurately attributed to them after being issued Social Security numbers that illegal aliens had previously invented and used. The overall impact on American citizens is largely unknown because federal, state, and local governments, as well as financial institutions, have generally failed to notify them even when fraud is suspected, end quote. Now, the Trump administration documented the extent of fraud, during which time it notified 1.6 million employers that they had employees whose Social Security numbers didn't match government records. The Biden administration then took over, has since brought in 5 million illegal immigrants to the United States, and the president stopped the practice of notifying employers of the fraudulent use of Social Security numbers. No doubt it was just too embarrassing. This has been going on for years, but it is sure to have grown exponentially during the Biden administration. We don't know how severe it is because the administration doesn't want us to know. The current process for holding illegal migrants accountable for ID fraud is bureaucratized to the point of absurdity. In one case, for example, an illegal alien trafficking and phony identification documents was placed in removal proceedings in 2005, and then nothing happened until 2013 when the endless appeals process was finally concluded. Despite the harm of Social Security fraud and the increasing number of illegal aliens committing it, there is no guarantee that an illegal alien committing it can be declared inadmissible to or be removable from the United States. In fact, in at least the U.S. Courts of Appeals for the 7th Circuit, the 9th Circuit, and the 11th Circuit, and potentially the 4th Circuit and the 10th Circuit, certain Social Security fraud offenses do not carry immigration consequences. In an 11th Circuit case, for example, the court held that an alien's conviction for using another person's Social Security number did not prevent him from receiving certain immigration benefits and remaining in the United States. Even though more federal courts find that a conviction for identification document fraud under 18 U.S.C. 1028 can make an alien removable from the country, that analysis can lead to years of litigation and involves convoluted legal analysis. In one case, for example, an alien was placed in removal proceedings in 2005, and I think I just mentioned that story. The bill changes that arduous, counterintuitive, and lengthy process by streamlining the analysis and ensuring that criminal aliens can be held to account and quickly removed from the country for victimizing Americans through Social Security and ID fraud. In doing so, the Consequences for Social Security Fraud Act protects Americans and strengthens the immigration system. I yield back the balance of my time and recognize the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, once again, the majority is looking for a way to scapegoat and fearmonger about immigrants. Today's legislation is a dangerous solution in search of a problem. Social Security fraud is a serious issue. And if there were a major loophole in our laws that needed to be addressed here, we would be happy to support the majority's bill. However, that is not the case. Serious convictions for Social Security fraud are largely already captured by our current laws. Unfortunately, this bill seeks to expand the ability to remove and deny people entry in a way that goes too far, and I cannot support it. This bill applies to individuals who are convicted of fraud, as well as to individuals who admit to committing fraud or to committing acts that constitute the elements of two specific fraud-related statutes. It would make those individuals inadmissible and deportable from the country. While I am troubled by the inadmissibility section and its potential unintended consequences, I want to focus on the deportability grounds, where I have the most serious concerns. One of the many ways someone can become deportable is if they are convicted of a crime involving moral turpitude, commonly called the CIMT, for which a sentence of 1 year or longer may be imposed. While the term is quite vague, for the purposes of this bill, CIMTs are generally understood to include crimes involving intent to defraud or deceive someone else. This means that individuals who are convicted of the fraud and deceit-related crimes referenced in this legislation are already deportable. Unfortunately, the majority then decides to go well beyond current law by not actually requiring a conviction for people to be deported. They do not even require the person to be charged with a crime. That offends all basic notions of due process and fundamental fairness. Let's remember who this section of the bill is targeting. This is not about undocumented immigrants who are, of course, already removable. And this section is not about people who are seeking to enter the United States. This section concerns people who have come here the so-called right way. We're talking about lawful permanent residents, people who have put down roots in our communities, many of whom have U.S. citizens, spouses, and children, and who have truly established themselves here in the United States. Many of these individuals are eligible to become U.S. citizens today. If they are convicted of Social Security fraud, they are generally already removable. While there are exceptions, the majority of the deportability grounds require a conviction for good reason. In addition, if Mr. McClintock's legislation were to become law, it would lead to absurd consequences. It would actually be easier to deport someone for offenses related to Social Security fraud than it is to deport someone for murder, rape, or sexual abuse of a minor, because for those crimes, a conviction is required. Is this really what supporters of this legislation are looking to accomplish? Does this make our country stronger or more secure? I hope the majority is willing to put aside their desire to score cheap political points and work with us to improve this legislation. Otherwise, I must urge all members to oppose it. I yield back the balance of my time.
Without objection, all of their opening statements will be included in the record. I now recognize myself for the purpose of offering an amendment in the nature of a substitute. Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 6678, offered by Mr. McClintock of California.
Without objection, the amendment in the nature of a substitute be considered as read and shall be considered base text for the purposes of amendment. This amendment simply makes small technical changes on pages 1 and 2. It doesn't change the substance of the bill, and I yield back. Who seeks recognition? Mr. Correa.
Thank you, Mr. Chairman. I wanted to ask a question of clarification, sir. We have a situation, many situations back home where we have individuals that have worked in this country 20, 30, sometimes even 40 years with essentially a Social Security number that's questionable. A lot of these individuals are now retiring and will not be able to draw from the Social Security system because they've worked with a questionable Social Security number. So these individuals have worked 20, 30, 40 years, paid into the system, not eligible to receive their benefits, can't retire on Social Security, and now under this legislation, they essentially are removable under another ground, so to speak. Is this what we're talking about here, Mr. Chairman?
Well, I'm not sure. Perhaps the gentleman can define what he means by a Social Security number that's questionable, that they made up or that they stole, which is a crime, Mr. Correa. And in this country, we ask guests of our country to obey our laws. And if they don't obey our laws, we need to show them the door. That's what this is about. And by the way,
Mr. Chairman,
it's not a question of conviction. It's
time, not yours. Mr. Chairman, let's clarify. Most of these individuals don't steal Social Security numbers. They're essentially created somewhere outside of the Social Security office. So essentially, they are working with an invalid Social Security, which comes back to the issue of E-Verify. As you know, in the farm worker industry, in farms, a lot of individuals work with invalid Social Security numbers because they don't have a green card.
The gentleman yield.
Yes, yes.
In effect, what you're saying, if I understand you correctly, is that someone else falsified a Social Security number. These people are victims. Is that correct?
That's partly true. That's correct. They didn't falsify it themselves. They've got a
they
Social
bought it from
Security.
somebody who falsified it.
But, Mr. Chairman, you asked a question, which is, did they steal it? These individuals, for the most part, do not steal Social Security numbers. They work with invalid Social Security numbers. So, Mr. Chairman, just a point of clarification.
Would the gentleman yield?
If I can.
Does it mean that the workers are being exploited and given fake Social Security numbers so that they can come in here and do the work that needs to be done?
They are giving.
A yes or no is good enough.
Yes. And the question I'm trying to get some clarification from the chairman, which is that that's what we're talking about here. So one of these individuals working as a farm worker at a California ranch, now under your proposal, they'd have a second reason to be deported.
If they admit to it, yeah, this isn't just a question of conviction. They have to admit to it under this provision. But if they've admitted to falsifying documents, to stealing people's Social Security numbers, to fraudulently inventing those numbers, or to buying forgeries from individuals with fake Social Security numbers, yes, it's time to show them the door.
Mr. Chairman, most of the farm workers in our California farms are working with Social Security numbers that somebody gave them or sold to them so they could work at those farms.
Which is a crime.
Okay, but under your legislation, this becomes an additional deportable. Yes.
That is a crime. That is a crime by the person who falsified it and gave it to the farm worker.
Or sold it to them, that's correct.
Not a crime by the farm worker,
Correct.
who is the subject of the bill and would be deportable.
Mr. Chair, is this correct? I mean, is that where we're going now? So now the issue of the crime, the individual that could, working innocently with a Social Security number that's
There's
not
nothing
valid.
innocent about Social Security fraud, Mr. Correa, and that's what this bill addresses. This is what you would try to excuse.
Who would be the victim here?
The victim is the individual whose Social Security number who has been stolen.
They're not stolen.
If they're invented, they're made up, often corresponding with somebody else's number.
Who would be the victim here?
The person whose Social Security number has been stolen or fabricated.
Chairman, they're not stolen.
And if the individual is buying forged documents, that individual is not a victim, that individual is a criminal.
For the purpose of working. For the purpose of working.
For the purpose of breaking the law, because if they're here illegally, it is illegal for them to be working.
So, Mr. Chairman, just to clarify my last second, we're creating a situation for now that individual that's working is subject to another criminal.
The individual who committed the crime and admits to committing the crime is deportable under this legislation. You are correct, Mr. Correa. Congratulations. The gentleman's time has expired. Further discussion, Mr. Biggs.
Thank you, Mr. Chairman. So I was intrigued by that last colloquy. So if I understand correctly, the argument from some of my colleagues across the aisle is if you buy a packet, and that's what we call them back home, a packet. You can get them in downtown Phoenix and Tucson, and all over the state. You go in, and it's a beautiful packet because you're getting a Social Security card. It's tougher to get a driver's license today, but you're getting identification documents. If you buy that packet, I thought I heard the ranking member say that's not a crime. That's really interesting.
Gentleman yield.
It is, no, not yet, sir. It is in Arizona. That's a crime. And when I'm heard that's a victimless crime, some of those Social Security numbers will have been acquired through theft because the forger who's creating the Social Security card has stolen the Social Security number. Can you think rationally? Let's say we step back on this and say, can you think of anybody? Can you think of anybody who would go? Hold on a sec. Can you think of anybody who would say, "Gosh, I'm going to get a Social Security number by going down to the corner of Jefferson and 5th Street in downtown Phoenix and giving somebody $100 to $150 and get that Social Security card." Does anybody really believe that the person who's doing that is saying, "You know what? I'm getting a valid Social Security number. I'm in the country illegally. That was my first crime. But this, I'm surely making it right by buying this ID packet." I mean, that stretches credulity. I used to be in the legal system working on this stuff. There isn't anybody who said, "Oh, yeah, I really thought that was a valid Social Security number. Thought it was good. That was gold. Back then it was 25 bucks you could buy the packet for. Now it's about 100, 150. I mean, to basically say it's not a crime if you buy this Social Security card is absolutely stretches, it's mind-blowing to me. It stretches credulity. I mean, there's not much more you can say because clearly the distinction that we have between the sides is not just a chasm, it is an abyss of misunderstanding. Because the reality is you have people, you actually have people who are victims that have their ID stolen all the time, every day, millions of people. I've had my ID stolen. Who hasn't had their credit card information stolen? Anybody on this committee not had the pleasure of trying to rebuild your credit card? So the point I guess I'm trying to make is it not yet? I didn't interrupt you either, by the way.
No, you didn't.
Is when you say who's the victim, I'll tell you the victim is the American people. Because you have somebody who's entered the country illegally and then has the audacity to say, hey, I bought a Social Security card. What's the problem there? The problem is you're committing fraud. And the way this bill is structured, you got to be convicted of it. So, if you've committed Social Security fraud, I'd like to know why you're running around with a Social Security card in the country. If it's not fraud, if you didn't go to the Social Security office. Because oddly enough, those who are in the country illegally can procure identification cards and information from the Social Security office. Yield.
Mr. Gentleman yields back. Further discussion, Ms. Jayapal.
I have an amendment at the desk.
Clerk will report the amendment. Gentleman reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 6678 offered by Ms. Jayapal of Washington. Page 2, beginning on line 11, strike, quote, who
Without
admits...
objection, the amendment will be considered as read. A gentleman from Arizona reserves a point of order. The gentleman
Thank you, Mr. Chairman.
Recognized for 5 minutes.
I'm so glad that Mr. Biggs and I agree. Again, we've done some great work together on FISA reform and protecting privacy of Americans. And now Mr. Biggs agrees with me that this bill should require a conviction for deportability, which it doesn't currently do. So my amendment is super simple. And Mr. Biggs, I can't wait to have you vote yes on it. It's simple, it's common sense. It actually merely ensures that we don't deport lawful permanent residents unless they're actually convicted of the crimes discussed in the bill. Because there's been a lot of crazy stuff happening in this markup. There's so much inconsistency that even my Republican colleagues are confused about whether or not the bill requires a conviction. This does not require a conviction in order to deport lawful permanent residents. So here's the situation. We are doing all these bills because we're still trying to distract from the fact that the Republican majority has been unable to govern and pass basic bills on the floor. So instead, how are we spending our time? Earlier this week, we voted on a pointless resolution related to the border, which will do absolutely nothing to address the situation at the border or fix our broken immigration system. And today, we're debating bills like these, which have no chance of going anywhere in a democratically controlled Senate, that are merely intended to try and score cheap political points as we head into a presidential election year. I really don't understand why my colleagues are offering this bill now, given that last week we discussed how undocumented immigrants pay billions of dollars into Social Security, even though they're not eligible for these benefits. We discussed how in 2019 alone, undocumented Mexican workers contributed $14.5 billion to Social Security and Medicare through taxes taken out of their paychecks. We need to remember that immigrants are engines of growth for the economy and the country. Now, turning to today's legislation and my amendment. Now, overall, I've got deep concerns about the bill. Not only is the legislation not needed, we've had no hearing, no testimony where Social Security fraud among immigrants has been identified as a problem that needs to be addressed. H.R. 6678 would amend the Immigration and Nationality Act to create a new ground of deportability for any non-citizen who admits to acts involving the essential elements of Social Security fraud. There is no requirement to my colleague, Mr. Biggs, and I hope we can work together on this like we've done on so many other non-immigration related things, but there is no requirement in this bill that the non-citizen actually be charged by law enforcement, have their day in court, and be convicted of a crime. And I'm so happy to hear you say that you too think that this bill should convict people of a crime before they're deported. Under current law,
The gentlelady yields, and she is putting words in my mouth.
I will, just in a minute. Under current law, a person does not need to be convicted of a crime to be inadmissible. But under most circumstances, you do need a conviction to be deportable. Current law allows people to be deported for Social Security fraud. Under the INA, the offense of falsely making, forging, counterfeiting, or altering a document that can be used as evidence of authorized stay or employment in the United States is specifically defined as an aggravated felony. If the crime carries a sentence of 365 days or a year or more, conviction for an aggravated felony makes a person deportable. Likewise, numerous jurisdictions have ruled that this type of fraud is a crime involving moral turpitude. Conviction of such a crime can also make a person deportable, but the key word there is conviction. As the ranking member mentioned, this bill would result in non-citizens being deported for offenses related to Social Security fraud without actually being convicted, let alone charged with committing such crimes. That is not consistent with current immigration law, and more importantly, it violates the bedrock principles of fairness, due process, and the rule of law. That sets a very dangerous precedent for several reasons. First, the people who would be most impacted by this new law would be green card holders. This is not about undocumented immigrants who are already removable. These are immigrants who my Republican colleagues, again, like to say have done things, quote, the right way. Do we really want to be deporting these individuals, many of whom are eligible to apply for citizenship without due process, without a day in court? Secondly, as I mentioned, with a few exceptions, the grounds for deportation under Section 237 of the Immigration and Nationality Act require a criminal conviction to make a non-citizen deportable. These include aggravated felonies like murder and child pornography and sexual abuse of a minor, as well as firearms offenses and crimes of domestic violence. Are we really saying that a Social Security fraud offense is so much more serious than these crimes to the point that it warrants the deportation of a green card holder without an actual conviction? By not requiring a conviction or even a charge, this bill would vastly expand the ways in which a green card holder could become deportable with the potential for massive unintended consequences. Hope my colleagues are willing to vote aye on this amendment.
Thank you. I'm going to recognize myself for 5 minutes. I do want to put the gentlelady's concerns to rest. What she doesn't seem to recognize is that this bill does require a clear admission by the perpetrator that they have committed Social Security fraud. And contrary to their talking points, not every grounds for inadmissibility and removability in the Immigration and Naturalization Act requires a conviction. This requires, however, a clear admission. In fact, the language is identical to the grounds of admissibility for crimes involving moral turpitude that you've mentioned and controlled substance offenses under INA 212A2. We've been through this discussion now 3 or 4 times today, and it doesn't seem to register with the Democrats. This requires an admission of guilt, even for grounds of removability. Convictions are not always required. For example, an alien can be removed for overstaying his visa, violating his non-immigrant status or condition of entry, smuggling aliens, committing marriage fraud, using a drug user or drug addict, falsely claiming U.S. citizenship, or engaging in espionage. By requiring at least an admission, this bill conforms to the pattern of other grounds of inadmissibility and removability in the law. In a world of unsafe streets and far-left prosecutors who may never prosecute these crimes or will allow aliens to plead down to crimes that may not make them deportable, it makes no sense to strike the provision to require a conviction. If an alien is admitted to such conduct, why can't the alien's own admission be used to show that the alien is inadmissible and deportable? I mean, this is really bizarre. If an illegal alien crosses the border without any kind of identification, whatever name he gives, whatever personal information he gives, we have to take his word for it. But when he admits to stealing a Social Security number then and only then we're not allowed to take his word for it. That is the strange world that the Democrats have created.
Would the gentleman
I
yield
back.
for a question?
I'll certainly yield for a question.
Admits to who?
Say again?
Admits to who?
Admits to the authorities.
It doesn't say that.
Well, an admission is an admission to whomever it's addressed.
Well, an admission could be, I mean, any kind of circumstance.
Yeah,
You could have an
I
individual who
stole
comes
that
in.
Social Security number,
You
and that's not enough for you. It is enough. It is enough for
let
you
me
to accept
ask
the
the
name
question.
he gives you at the border
Let me
without
ask-
any identification.
Let me
But
ask
when
the
he admits,
question.
when he admits to taking this action,
Let me ask the
somehow
question
that we're
about
not
what
supposed
your
to
language says.
accept.
Let me
Sorry?
ask the question about what your language
Yeah.
says, okay? Could it be an admission to a third party who's not law enforcement or a judicial official?
Well, I'm not a lawyer, but I think that that would probably be hearsay, would it not?
You don't have requirements for the
But
federal rules
there's
of evidence
already-
under this provision,
But-
but you're
but-
not even in a court if you're just taking an admission for as sufficient for
But again,
deportation.
this is a provision we have for a whole range of other acts that I just went through. This simply adds this to those other acts, which are pretty serious stuff.
So you're not willing to define or limit who the admission would be to?
As a matter of fact, I do have the answer for you here. For 80 years, the Board of Immigration Appeals has provided additional protections for aliens whose removability or inadmissibility is based on an admission. Under the BIA precedent, to be considered an admission, an alien's admission must be explicit, unequivocal, and unqualified. The Department of Homeland Security then bears the burden to show by clear and convincing evidence that the statement meets the requirement for removability purposes. Even then, the immigration judge would have to find that the admission fits within the relevant statutes and that the admission is based on reasonable, sustainable, and probative evidence. The statutes cited in the bill have clear elements that shouldn't be a surprise to you or to anyone else.
All right.
Does that answer the question?
Yeah, so the admission could be to anyone, but the judge will determine whether it is reliable?
That's my understanding of the bill, yes. Yeah, I'll yield to Mr. Biggs, who is a lawyer.
Well, that's because you're in removal proceedings, and that's where the statutory cross-references take hold there. So, and the other thing I would just say is, this does have a conviction portion to it, but you're adding the admission if someone makes that admission. But that's, you've already got yourself into court on the underlying issue here.
I believe we're on my time and that's expired. Further discussion. Ms. Escobar.
Thank you, Mr. Chairman. I rise to support my colleague's amendment, which I think is a very common sense amendment. Deportation is an incredibly serious step for the federal government. There should, at the very least, be a conviction in a case like this. But in addition to articulating my support for the amendment, I also want to point out something that is, again, yet another example of the continued effort to really demonize immigrants at every turn. This issue about Social Security fraud, not a single member on the Republican side of the aisle mentioned the businesses that were taking advantage of immigrants desperate enough to work that they would use a false Social Security number. Not a single mention of the abuse of those business owners, of the illegal engagement by those business owners, not a single conversation about any consequences for those business owners. No, because in this case, the singular purpose behind this committee's efforts around immigration is simply to demonize vulnerable people as often as possible at every turn and not offer reasonable or real solutions. because this issue is far too potent for them, far too powerful. But if push comes to shove and it's time to really talk about real solutions, nowhere to be found. Anyway, Ms. Jayapal, thank you so much for your amendment. You have my full support. And I yield back.
Gentlelady yields back. Further discussion, Mr. Van Drew.
Very quickly, because the time is growing late. Nobody's attempting to demonize anything here. It's not too simplistic to say that illegal is illegal. That's why they're called illegal migrants or illegal immigrants. It is illegal. You're breaking the law already. And we're going through the fine-tooth comb to try to find technicalities one way or the other. No other country in the world would allow this. No country prevails with open borders the way ours are right now. They're breaking the law already. That's what matters here. So this is just one more provision, but the point is people who come here illegally, all the millions that are coming in the last few years, they're not supposed to be here. They got here illegally. It's wrong. I yield back to the chair.
Gentleman yields back. Further discussion on the amendment? Seeing none, the question occurs on adoption of the amendment. Those in favor of the amendment say aye. Aye. Those opposed say no. No. The noes appear to have it. Roll call is requested. Secretary, call the roll.
Mr. Jordan, Mr. Issa, Mr. Buck, Mr. Gates, Mr. Biggs. Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey. Mr. Roy. Mr. Bishop. Ms. Spartz. Mr. Fitzgerald. Mr. Bentz. Mr. Bentz votes no. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Nels votes no. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Mr. Moran. Mr. Moran votes no. Ms. Lee. Ms. Lee votes no. Mr. Hunt. Mr. Fry. Mr. Fry votes no. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson. Mr. Johnson votes aye. Mr. Schiff. Mr. Schiff votes aye. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Mr. Neguse. Ms. McBath. Ms. McBath votes aye. Ms. Dean. Ms. Escobar. Ms. Escobar votes aye. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Issa. Mr. Issa votes no. Mr. Chairman, there are 10 ayes and 14 noes.
The vote being 10 to 14, the amendment's not agreed to. Are there any further amendments? Seeing none. There we go. We don't have any. Oh, yeah, we do. Questions on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor of the ANS say aye. Aye. Those opposed say no.
No.
The ayes appear to have it, and the amendment in the nature of substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no.
No.
The ayes appear to have it.
Roll call, please.
Roll call is requested. Secretary, call the roll.
Mr. Jordan. Mr. Jordan votes yes. Mr. Issa. Mr. Issa votes yes. Mr. Buck. Mr. Gates. Mr. Gates votes yes. Mr. Biggs. Mr. Biggs votes yes. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparks? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes aye. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Schiff votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no.
Have all members voted? Secretary, report.
Mr. Chairman, there are 15 ayes and 11 noes.
Vote being 15 in the affirmative, and you said 12 in the negative? 11 in the negative. The bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. That's not an adjournment. Pursuant to notice, I call up H.R. 6679, the No Immigration Benefits for Hamas Terrorists Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 6679, to amend the Immigration and Nationality Act with respect to aliens who carried out, participated in.
Without objection, the bill will be considered as read and open for amendment at any point. The chair will now recognize himself for 5 minutes to explain the bill. 3 days ago, we marked 100 days since Hamas initiated its brutal and unprovoked terrorist attack on Israel. It was the deadliest terrorist attack since the State of Israel was formed. And in 2 days, we're going to mark the 3-year anniversary of the Biden administration's executive orders that opened our nation's borders to the world. Since then, more than 7 million illegal aliens have illegally crossed our border, a population the size of the state of Tennessee. 5 million, including 1.7 million known gotaways, have been released into the United States, a population the size of the state of Alabama. A few days ago, Secretary Mayorkas admitted that DHS is currently releasing 85% of the illegal aliens coming to our border. When we were in Eagle Pass 3 weeks ago, Border Patrol officers told us that the figure in their sector is more than 90%. And of course, 100% of the known gotaways enter the United States, about whom we know precisely nothing. That's a 2,700% increase since Biden took office and deliberately opened our border. Our law enforcement agencies are now urgently warning us of the national security risk that this has created. When Biden abandoned Afghanistan, he released 5,000 of the most dangerous terrorists on the planet. How many of them are among the 1.7 million gotaways? We know that suspected terrorists that have been apprehended have exploded exponentially since that time. FBI Director Chris Wray warned this committee that this constitutes a, quote, massive security threat. His words, a massive security threat. Just let that sink in. And then consider the barbaric terrorist attack 103 days ago in Israel. I believe it's just a matter of time before we see a coordinated terrorist attack in our own country from elements that have entered as a direct result of Biden's policies. We've already seen lone wolf attacks in Belgium, France, Germany, and Denmark because of their lax border policies, and I'm afraid this is only the tip of the iceberg. After the October 7th attacks, Director Wray warned that America, quote, cannot and does not discount the possibility that Hamas could exploit the conflict to call on their supporters to conduct attacks on our own soil, end quote. Here in the U.S., at least one foreign national has already been arrested for plotting an attack against Houston's Jewish community, a Jordanian national who had overstayed his visa several years ago, but then applied for asylum and was issued work authorization by the Biden administration. This bill is a very small step in combating this danger. It classifies members, officers, officials, representatives, and spokespeople for Hamas and the Palestinian Islamic Jihad as being engaged in terrorist activity for the purposes of inadmissibility to the United States. The No Immigration Benefits for Hamas Terrorists Act further provides that those who participated in or otherwise facilitated the attacks on Israel beginning on October 7th are inadmissible to and removable from this country, and makes such aliens ineligible for all immigration relief under our laws. Now, this obviously is not going to stop the influx of terrorists into the country. Only an administration committed to securing our border and protecting Americans can do that. And at the moment, we don't have one. And that can only be fixed by the American people. But this bill does send an important message around the world. If you've associated with Hamas, you will get no comfort or quarter here. You are persona non grata in America, and you should be, as you should be in any corner of the world that values peace, justice, and human dignity. With that, I yield back and recognize the ranking member, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, on October 7th, 2023, Hamas committed a horrific assault on innocent civilians in Israel, murdering 1,200 people, including 32 Americans, killing the most Jewish people in a single day since the Holocaust. They kidnapped over 240 people, citizens of countries around the world, Jews and non-Jews alike. Even today, over 100 days later, Hamas continues to hold innocent men, women, and children in captivity. Not a day goes by that I don't think of the hostages, of Hirsch Goldberg, Poland, the Bibas family, and Noah Argamani, of Oded Lifshitz, a peace activist who remains in captivity months after his wife Yocheved was released, of too many others whose names and stories would take me far more than the 5 minutes yielded to me to recount. The attacks and the war that followed have been a nightmare from which we have been unable to wake up. Too many lives have been lost, too much innocence has been shattered on both sides of the conflict. Today, the majority has put forward legislation with a worthy goal, ensuring that no one involved with the planning or commission of the October 7th attacks can enter the United States or receive any immigration benefits. However, such individuals are already barred from entry and cannot receive any immigration status. Hamas has been a designated terrorist organization by the U.S. State Department since 1997. Under Section 212A3B of the Immigration and Nationality Act, any non-citizen who has engaged in terrorist activity, provided material support to terrorists, or is a member or representative of a terrorist organization or a group that endorses or espouses terrorist activity is inadmissible to the United States. Furthermore, the national security-related bars in Section 212A3 of the INA are very broad. To bar an individual, as Secretary Milley needs, quote, reasonable grounds to believe, close quote, that the applicant presents a risk to national security or is otherwise seeking to engage in, quote, any unlawful activity in the United States. This authority applies to those who engage in or endorse terrorist activity, as well as those who provide material support to groups that take up arms against government forces. The breadth of this provision is so extensive, it has been used to bar someone from accessing asylum who was forced to cook and clean for a guerrilla group. As such, this bill is largely redundant to current law. However, the aim of this legislation is something I certainly support. No individual who was involved in or aided these heinous attacks should be eligible for a visa to come to the United States or be eligible for any form of immigration relief. That is why I intend to support the bill as it moves through committee. However, I would ask that the majority work with us to discuss potential changes before it comes to the floor. The legislation before us is written in a very unusual way. When we wish to prevent specific bad actors from entering the United States or accessing an immigration benefit, we use visa sanctions legislation. This type of legislation is something this committee has handled in a bipartisan way for decades. We have pre-negotiated bipartisan, bicameral text that we use for every visa sanctions bill. Today, however, the majority has chosen to directly amend the INA to impose visa sanctions. To give some perspective as to how unusual this is, after the September 11th attacks, we overhauled whole swaths of our immigration system, including creating the Department of Homeland Security, but we did not amend the INA to specifically bar the people involved in the planning and commission of those attacks from entry into the United States. Visa sanctions would have the same effect that Chair McClintock is looking to impose with this legislation. Individuals who were involved in or supported the October 7th attacks would be ineligible for a visa or for any immigration benefit, including asylum. I'm concerned that amending the Immigration and Nationality Act to effectively impose visa sanctions sets a dangerous new precedent and could have unintended consequences. The legislation makes individuals ineligible for immigration relief or any visa, quote, for attacks against Israel initiated by Hamas beginning on October 7th, 2023, close quote. By departing from carefully negotiated sanctions language, the majority's legislation is open to misinterpretation and confusion. Putting this specific date into the INA could imply that those who participated in terror attacks prior to October 7th might be eligible for visas, despite the clear bars elsewhere in the Act. I share the majority's desire to ensure that no one involved in the October 7th attacks obtains any immigration benefits from the United States. I hope we can work together to improve this bill and ensure its effectiveness. But most of all, I hope for a time when bills such as these are no longer needed, when Israelis and Palestinians can live side by side in peace. These days, I have found myself thinking often of a line from the book of Yeshayahu, or Isaiah, Lo yisagayel gai charev, lo yimadu od milchama, which translates to, nation shall not lift up sword against nation, neither shall they learn war anymore. May we soon live in a time when these words come to pass. I yield back.
The gentleman yields back. I have an amendment at the desk. The clerk will report.
Amendment in the nature of a substitute to H.R. 6679.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The amendment makes a technical change and a grammatical change on page 3. It adds conforming amendment and does not alter the substance of the bill. With that, I'll yield back. Who seeks recognition? Mr. Ivey.
Thank you, Mr. Chairman. I promise not to go long, Ms. Ross. But I did want to say a couple of things on this because this is an issue that's of particular importance to me and many of my constituents. So I'll speak briefly on this. I certainly share the ranking member's concern, targeting this legislation that only targets Hamas members who participated on the October 7th attack and subsequent, I think is a bad idea because there have been Hamas attacks for years. And so why we would want to, I just assume this is a drafting error of some kind. And
well, with the gentleman yield, it also affects anyone who is a member of Hamas or an official with Hamas at any time.
I appreciate that, and as the ranking member pointed out, that's already covered by the definition for Hamas as a terrorist organization, but I do think the October 7 language should be dropped. But the bigger point I want to make is this. This is a largely symbolic piece of legislation, and that's fine. We do a fair amount of that here. But we've got two really big pieces of legislation pending before the House that are not symbolic. One is military aid to Israel, and the other is humanitarian aid to Gaza. They've been sitting around here in the House for weeks now, and I think we should stop sitting on them. The Republican leadership decided to combine the Israeli bill with the IRS bill, and that there's some strategic reason they did that, I suppose. I don't think that's the right piece of legislation to be playing these kinds of strategic games in the middle of a hot war. And then with respect to aid to Hamas, the Palestinians in Gaza, Israel's fighting Hamas, they're not fighting the Palestinians. Gaza is a mess by any measure. The devastation that's taken place there due to the military offensive. and I'm not trying to, point fingers about anything there, but everybody I hear from says that starvation, disease, just total, the negative impact on the people who are there calls out for immediate humanitarian aid from the United States and from other countries. So bring up the vote, I'll support it, but my hope, I'm asking my colleagues on the other side, but all of us here in the House, to move forward on these two pieces of major legislation as fast as possible. It's an immediate need, and with respect to the humanitarian aid aspect, lives are hanging in the balance. With that, I yield back.
Gentleman yields back. Is there further discussion?
Mr. Chairman.
Ms. Jackson-Lee.
No one can defend or, if you will, diminish October 7th. And so I joined with my colleague, the ranking member, Mr. Nadler from New York, in his eloquent expression of both the words of the scriptures, but also the words of what occurred on that day. And to recognize that I, for one, and others of my constituency cannot counter such violence, such abuse, such rape, such mutilation of children. And I believe that though present law covers much of what is in this legislation, what is worthy is that we reinforce and reaffirm the heinousness of what happened on October 7th and the fact that we have an affection for human life and an affection for the people who were innocently either in their homes or enjoying a concert. Likewise, I know that my constituents represent those who have an affection for people who are desperately in need in Gaza and need the humanitarian aid desperately, the medical aid desperately, the aid to help their babies, the aid to help the elderly. And so as we cast our votes for this legislation, which just, from my perspective, says the obvious that terrorists have no place in the United States, they have no place in a process and system of governance that is one built on democratic principles. They have no place in getting the benefits of the wonderment of this great nation. Then I know that we will also, as great humanitarians at this table, have great love for the innocent people in Gaza that I've heard comes from all around our communities. So I end by saying I demand, and we have consistently fought and raised our voices for the hostages to be returned, and consistently demand that the heinousness, the horribleness, the violence, the viciousness, the bloodiness of Hamas actions on October 7th never be forgotten. And that as well, the people who are lost their lives in this process, innocent persons in Gaza as well, we continue to try and bring relief. Because that's what humanity does, that's what human beings does, and that's what I hope we intend to do as well. With that, I yield back.
Gentlelady yields back. Further discussion? Mr. Johnson.
Thank you. I rise in support of the legislation, and but I would be remiss to let this opportunity go by with what has been said thus far, with nothing having been said about the ongoing offensive in Gaza, which has now led to the deaths of 23,000+ Gazans, 70% of whom are women and children. They have to be innocent if they're women and children. And many men who are innocent have been killed. Gaza is being leveled, and the people, the 2.3 million people who live in a 25 square mile area about the size of my home county, 2.3 million people living there, subjected to a blockade and land barriers that prevent them from leaving. And the only thing they can do is dwell there while the bombing continues. No safe place left for them to dwell. They were told to leave the north and go south. The North was bombed. The South is bombed. All to eradicate hate or Hamas. You can't eradicate hate in that way. The only thing that can eradicate hate is love. Opposite of dropping bombs. The bombing must end. It'll end at some point. The question is how many innocent civilians will have been killed? Will it be 2.3 million? If we keep going, that's what it will be, either through bombing or through starvation or sickness and disease. So I'm in favor of a ceasefire, and having said that, I will yield back the balance of my time.
Gentleman yields back. Is there further discussion? Seeing none, I just simply want to thank the ranking member for his constructive comments, and look forward to working with him. If we can reach a bipartisan consensus on this, that would be a very good thing. With that, questions on the adoption of the amendment and the nature of a substitute. This will be followed immediately by a vote on the reporting of the bill. Those in favor of the ANS say aye. Aye. Those opposed say no. The ayes have it, and the amendment and nature of a substitute is adopted. Reporting quorum being present, the question is on favor of reporting the bill as amended. Those in favor say aye.
Aye.
Aye. Those opposed say no. The ayes have it. A roll call has been requested. The secretary call the roll.
Mr. Jordan? Mr. Jordan votes yes. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes yes. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Nagoose? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush?
I'm gonna do it.
Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
Clerk will report.
Mr. Chairman, there are 24 ayes and 0 noes.
The ayes have it. The bill is ordered.
Mr.
reported
Chairman.
favorably to the House.
Mr. Chairman.
Ms. Jackson-Lee.
Let us, we need to get.
What is he saying? Oh, okay, housekeeping.
Thank you. Members will have 2 days to submit their views. Without objection, the bill is going to be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff's authorized to make technical and conforming changes.
Mr. Chairman, on H.R. 6678, the Jayapal Amendment for a Conviction Consequence for Social Security Fraud Act, I was unfortunately detained, and I would have voted aye on the Jayapal Amendment to require a conviction. I'd like to be unanimous consent to be recorded as appropriate in the record.
Without objection.
Thank you.
That concludes the committee's business for this meeting, and the meeting is adjourned. And this is an adjournment. Oh, this